Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is April 20th. It is 9 a.m. This is our regular Wednesday meeting. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Very good. That is a quorum. Good to see everybody again. We see folks are rolling in. We have 29 folks with us so far and counting. We will roll through our agenda. We have a commissioner comment section, a consent agenda, and one variance request on the agenda today. So we will start with commissioner comments. Does any commissioner have thoughts for us for the good of the cause this morning? Commissioner Gonzalez.
Yeah, thank you, Chair. I've got a quick announcement to make and a quick comment, so I'll go ahead and do that now. As many of you know, I was appointed to this commission for a 2-year term. That term comes to an end on June 30th. I have immensely enjoyed the work that we've done to strengthen Colorado's oil and gas rules in a workable framework, and I'm confident in this commission to continue applying protective and pragmatic regulation to Colorado's oil and gas operations. The individuals with whom I've spent this great responsibility are some of the most thoughtful and engaged professionals I've ever worked with. We've strived to work together respectfully and constructively to make decisions that are shaped by each person's unique experience and perspective. And I expect that to maintain as this body brings on 2 new members in the near future. Something I will value most is the time that I've spent with this agency's hardworking staff who continually show dedication to their jobs and to this state. And lastly, I'm grateful to Governor Polis for giving me the opportunity to help stand up this first professional commission and set us on the right course under our new mission. That's kind of going to summarize that I'm ending my term here on June 30th, that my term will come to an end. And I want to throw out a plug that if anyone with experience in the oil and gas industry has ever considered serving our state, that I would highly recommend this opportunity. It's been a wonderful time for myself. And if anyone has any questions, I'm glad to answer them. And I know that Director Murphy and Chair Robbins would also be available for that as well. So that's my comment for today. Thank you, Chair.
Thank you, Commissioner Gonzalez. One of the more important comments that we've received. We take it in good faith. We really have enjoyed your participation with us. I think you've added tremendous value to the work that we've done, and your shoes are big to fill. But I would echo the fact that if there are folks that are interested, please contact me or Director Murphy or yourself, Commissioner Gonzalez, and we look forward to the last couple of months working with you. And I know you will robustly fill out the remaining work portion of your 2-year tenure. So thank you very much.
I plan to do that. I got two months and a couple weeks, and I think we've got a lot of work to do in that time and look forward to finishing out strong.
Very good. Anyone else with comments for the good of the cause? All right, seeing none, we will move to consent agenda. We have 3 hearing officer recommendations. Does anyone have questions with regard to consent agenda? Seeing no questions, do we have a motion to approve consent agenda?
So moved.
Second.
We have a motion and a second. Is there any further discussion? Seeing none, all those in favor of consent agenda signify by saying aye.
Aye.
Any opposed? Consent agenda passes. Okay, with that, we will move to docket number 2201000008, Williford Resources variance request. See that we have Mr. Campbell, hearing officer Thomas, and I believe that we've got staff's attorney, Ms. Rosenberg. Good to see all of you. I have before me the final pre-hearing order. I think what I'd like to do is sort of start out by giving the applicant an opportunity to address any procedural issues. Having reviewed the filings, I note that there were some later filings from staff. I note from the pre-hearing order that the applicant requested some additional time to be able to address some of those matters. And I wanted to give the applicant an opportunity to just sort of talk with us. This is not counting against your time, even though the hearing order says it does. I just wanted to start with an initial discussion, Mr. Campbell, from you. In particular, I'm wondering, are you ready for full presentation today? I as a former practicing attorney, understand that there were some late filings here, and wanted to give you an opportunity if today is the day, or did some additional time to get prepared, would that be helpful? Just kind of have that discussion with you. And you are muted.
I'm sorry, can you hear me now?
I can. Yep. Very good.
Thank you, Mr. Chair. My name's Scott Campbell. I'm with the law firm Paulson, Dell and Peterson, and we're here on behalf of Williford Resources, LLC. And thank you, commissioners, for the opportunity to speak with you here today and consider Williford Resources, LLC's application. Mr. Chair, I think we're ready to go forward. We do have some concerns, reservations about the nature of staff's position and some of the questions it's raised, and more particularly the time in which those issues and questions came up in these proceedings. We believe we can adequately respond to those questions and concerns nonetheless, but under the circumstances, as we go through these proceedings, should it become apparent that there's more information that's necessary before the commission could act, then we would ask for at that time a brief continuance, maybe into the next week or something like that, just to get our ducks in a row. We don't think there's any prejudice to the state's interests here or staff. So with that said, let me just briefly touch on kind of how things evolved here. We filed our application. Staff filed a self-styled petition on March 16th, in which it rebutted certain legal positions we'd taken, requested that the matter get referred to the commission, given the nature of the variance request, and noted that staff was not taking a position on the variance otherwise, but that it might have technical issues somewhere down the road. Setting aside the question of whether or not those technical considerations should have been identified in staff's petition on March 16th, we would note that Rule 509A states that for matters in which staff is a party or a staff analysis has been prepared, the director will participate in the pre-hearing conference to advise the parties of the content of staff's analysis. And of course, a pre-hearing conference is conducted either at the discretion of the hearings officer or at the request of the applicant or the petitioner. And we were unaware staff was doing anything or that it was in the process of identifying any questions or concerns until the days leading up to this hearing. It is our view that it would have been the better practice for staff to have identified these issues much earlier in the proceedings and then asked for a pre-hearing conference wherein the director as the participant would have filled us in on those concerns, and we would have been ahead of the curve, so to speak, and better able to identify or respond to some of those issues. And and at least on one of those issues, we still don't know what it is or the nature of staff's objection, even though we had the opportunity to speak with staff yesterday. So for example, staff has stated that Williford does not properly report production for all wells. We don't know what staff believes Williford is doing incorrectly. And until we hear more from staff here today, we don't know how to respond to that particular question. So sorry if that was a bit long-winded. And we very much appreciate the time to take that issue up with you here first. To conclude, we think we can move forward. We'd like to move forward. We think it's in everybody's best interests to move forward. But we would just ask that the commission keep in the back of its mind that on some of these issues, there's at least a possibility that we might need a little more time to supplement the record should the commission believe the record's inadequate at this time. Thank you.
Okay, not quite the answer I was looking for, honestly. I generally would like both sides to be fully prepared and ready to roll. But we can take that under advisement, and we can move forward. And then, I'll take the caveat that if something comes up and you feel you're not ready to protect your client's interests in terms of evidence, et cetera, then we could, consider, a hold on the matter and giving you a little additional time to get fully prepared. I am going to recognize Ms. Rosenberg. Do you have anything in response procedurally before we move forward?
Just a couple of things, really just specific points. Staff's filing presentation was filed yesterday. It was based off receiving Williford's presentation. And for the commission's edification, staff did provide that to Williford Resources in advance of filing it, met with them, made some adjustments to the presentation based off that meeting, and then filed it after a pre-hearing conference yesterday where we discussed the matter a little bit more. Staff wants to be clear that it is not offering a position on the ultimate question about whether the commission should or should not grant the variance. Staff defers to the commission on that. And just consistent with staff's March filing, as noted on the first page, staff has continued to review Williford's materials and has some input on this matter. It does not rise to the level of counter evidence, as staff noted it may present in its filing. It is simply input related to the information that Williford has provided. And some of these materials were provided, I believe, Monday, although maybe they were provided Friday. So it's, some of this has been a little late, but there have been background discussions regarding this, and staff's position has been based off the materials that Williford provided for the commission.
Okay, thank you, Ms. Rosenberg. With that, I think we will, and commissioners, if you're comfortable with it, I think we'll roll into the hearing, give Williford their opportunity to present their case, and with the caveat that as we hear from staff, et cetera, I think we'll, act accordingly. So, all right, with that, Mr. Campbell, you are recognized for your piece.
Thank you, Mr. Chair. And let me start with sharing my screen. Excuse me. And are you able to see our presentation?
Yes. Yeah, now you're in full screen mode.
Thank you. Well, again, Mr. Chair and Commissioners, thank you for meeting with us here today. My name is Scott Campbell with the law firm of Post, Dell and Peterson. I'm here with my colleague, Rob Willis. And we are here on behalf of Williford Resources, LLC. And Hearn Williford, the owner and principal of Williford Resources, LLC, will be the witness here today to discuss the merits of its application. And more specifically, Williford Resources is asking for a variance from Rule 903 to continue to vent and combust minuscule volumes of casing head gas from a remote 3 square mile area for a modest 1-year time period from the date of the commission's order granting the variance, should it be granted, during which time he will be investigating how to build the proverbial better mousetrap, and hopefully in collaboration with commission staff. But before we jump into the factual issues here, there are some substantive issues that we at least want to preliminarily address. And more specifically, the commission will note, as presented in our presentation, the end of our presentation, Williford is arguing that there's one constitutional takings argument, and that the commission's Rule 903 may be ultra vires for 2 reasons. In other words, beyond the scope of the commission's jurisdiction. Before we get to, or whether we get to the details of those substantive arguments, I think we first need to address staff's responses to the presentation of those arguments. And more specifically, staff has raised 2 issues in rebuttal. One, staff is arguing that Williford can't appropriately make these arguments because it was not a party to the 900 series rulemaking. And 2, staff is arguing that the issues should be stricken as inappropriately raised here because the commission can't decide the issues. And 3, I guess there's 3 arguments. Staff has recently stated that 2 of the arguments have been presented to this commission too late. So let's kind of take those in turn. And with the first question being, can a rule be challenged as unconstitutional or ultra vires if the claimant was not a party to the rulemaking proceeding? And the answer to that is unequivocally yes. I mean, the Colorado Supreme Court has specifically addressed this issue twice. The first time was CF&I Steel Corp versus Colorado Air Pollution Control Commission, 610 P. 2nd 85 at 90 to 91 in the year 1980, where it said, it is enough that the regulation being enforced or applied to the party. It is enough that the regulation is being enforced or applied to the party adversely affected thereby. Therefore, there was no requirement that the party, the applicant in those cases, have participated in the underlying rulemaking. And specifically in that case, the question was whether AQCC fugitive dust regulations were being appropriately applied to a steel plant in Pueblo, Colorado. You know, another example is the Colorado Supreme Court's decision in 1981, Colopy versus Wildlife Commission, Department of Natural Resources, 625 Pacific 2nd 994 at pages 1003 through 1004, where the Supreme Court said, quote, the commission's assertion that Colopy should have petitioned for judicial review under section 24-1064 is simply untenable. The only agency action which could have been reviewed in such a proceeding was the promulgation of the rule. So the fact of the matter is that when a party is making constitutional or ultra vires challenges to a regulation as it's being applied to that party, there is clearly no requirement that the party first participate in the rulemaking.
Mr. Campbell?
Yes, sir.
Let me jump in to sort of expedite proceedings here. I, at least as one commissioner, and I have 3 others who will need to weigh in, believe that you have a right to a as applied facial challenge. And so to sort of cut through this, I would be comfortable in, making that statement, allowing you to be able to move forward more into the substance. But again, I'm one commissioner. I've got 3 others. Is any of the other commissioners uncomfortable with that tentative ruling on the ability to make a as-applied facial challenge at this point? All right, seeing none, you can move to your next argument.
Well, thank you, Commissioner, or Mr. Chair. I don't know that there's anything else we really need to address on those issues right now. Unless you disagree, and with your permission, we would just like to proceed on the merits of the application. And leave it to your discretion. There's a feedback there, excuse me. And leave it to your discretion as to whether or not you want to hear more about the substantive arguments. We are hopeful that the application will be granted as requested, in which case all those substantive issues are rendered moot. So with that said, I'm going to hand the reins over to my colleague, Rob Willis, who will conduct our direct examination of Hearn Williford.
Very good.
Chairman Robbins, this is Rob Willis. Can you hear me?
Yes, we can hear you.
Very good. I just kind of want to orient you with regards to what we're attempting to pull off today from a technological perspective. I'm with Mr. Campbell in a conference room with a different camera than what Mr. Campbell has. Over the last several months, I've gotten to know and enjoy Hearn Williford, who is the managing member of Williford Resources. He too is in this conference room today. It's my hope when we provide you information, testimonial information today, that there's going to be no feedback and that you're looking at the right exhibits, which Mr. Campbell is going to drive for me. So anyway, this could be a little bit clunky. I hope it's not, but I'd just like to first start off by introducing Mr. Williford. And also, he hasn't been sworn. I don't know if you want to do that.
Yeah. Let's recognize AAG Davenport to swear in the witness.
Mr. Chair, do both the folks know that we can't see them? I don't know if that's intentional or not, but just so they're aware, we can't see them.
Good point, Commissioner McGowan. We see Mr. Campbell, but we do not see Mr. Willis or Mr. Williford. Now we do. Welcome.
Okay.
Mr. Williford, do you want to do like testing 1, 2, 3, 4 and make sure we don't have like feedback problems?
Testing 1, 2, 3, 4.
I think that's okay. Okay, Mr. Davenport, do you want to swear in the witness?
Thank you, Mr. Chair. Yes, Mr. Williford, if you would just raise your hand and state your name and say that you swear to tell the truth, that's all you need to do.
My name is Alan Hearn Williford III, and I swear to tell the truth.
Thank you.
Thank you, Mr. Davenport. Mr. Williford, could you once again state your name and provide your education and experience to the commission? Let them know what you've been doing, how long you've been doing petroleum engineering, and how long you've been doing it.
Mr. Willis,
Yes.
I think we are getting some technical feedback. Yeah.
Feedback.
It may be because you're both in the same room and both have your speakers on.
I've tried to.
I'll just sit next to him. Yes, thank
I'll
you.
just sit next to him. Yes, thank you.
Commissioners, let's give everybody just a chance to reorient here and see if we can get that. We're not hearing crosstalk.
Very good. Once again, Mr. Williford, would you provide your name to the commission again, just for the record, and then also describe your experience and education as a petroleum engineer?
Yes, sir. My name is Alan Hearn Williford III. I go by Hearn Williford. I have a Bachelor's of Science degree in Petroleum Engineering from Texas A&M University in 1978. I've worked for Amoco, Williford Energy Company, Williford Resources. I've been a practicing petroleum engineer for every day of my life since I graduated college. I've testified in commissions in Colorado before, Texas, Oklahoma, and Arkansas as an expert witness in petroleum engineering.
Let's move forward to the PowerPoint presentation and maybe use that as a go by as best we can. Slide 2 is a roadmap that's been provided. Could you describe to the commission what that signifies?
Yes, sir. I made this exhibit because everybody's used to looking at roadmaps. And approximately, you see a red circle in the bottom left of the exhibit. It has a black triangle. It's also near the towns of Marvel and Red Mesa. This is about 20 miles southwest of Durango in a pretty remote area.
All right, very good. Let's move to slide 3. Slide 3 indicates that no protests have been filed and that you're requesting approval to continue venting casing head gas from category C wells and also continue to combust casing head gas from category A and B wells for 1 year. That's what your request is, right?
Yes, sir, it is.
So let's move forward then to maybe talk about category A, B, and C wells and what those categories signify. Slide 4, please. There was a need for you to be brought to the committee with the agency back in late 2016 and into 2017 was the effective date of the compliance agreement. The wells were carved up into 3 categories. Could you describe each category and why each category was relevant to that compliance agreement?
Sure, I will. Each category of wells, let's start with category A. Category A represented wells that were connected to Williford Resources gathering system. And then thus those wells were connected to the Red Mesa gas gathering system. And that's how we sold our gas to Red Mesa Holdings. Category B wells were wells that were not hooked up to the gathering system, but we negotiated with the commission and decided that it would be best that the category B wells were also connected to that gathering system. Thus, those wells were connected to the gathering system in 2017. Category C wells were wells that were either too remote, topography problems, right-of-way problems, just hardly any gas volumes. Those wells were not ever hooked up to Williford's gathering system and therefore did not sell to the Red Mesa gas gathering system. And the gas had been vented from those wells.
Before we talk about the Red Mesa gathering system, let me rephrase that. As we talk about the Red Mesa gathering system, the gas that you had produced or plumbed into the system, where did that gas go? Was there a consumer endpoint for that gas?
Yes, sir. Initially, the gas was supplied gas to the Durango area for domestic and industrial uses. Later, Red Mesa Holdings, due to losing that connection in the Durango area, they hooked their system up to Red Cedar, and we sold our gas to Red Mesa Holdings, and the end market was between Red Mesa Holdings and Red Cedar.
Now, when that gas was transferred to Red Mesa, did they test the gas? Just to your information.
Yes, they tested every month.
All right, and they would have also included testing it for H2S, hydrogen sulfide.
That's correct.
All right, and you never got any notice that they weren't accepting it because of any presence of H2S or anything.
There is no H2S.
All right, so let's move forward then to talk about more specifically the Red Mesa gathering system and whether or not it's available for transmission of gas into that market space again. Could you describe that to us? I'd like to refer you to slide 5.
In February of 2016, the commission had an order number IC-10, which required the successor to Red Mesa gathering system to cease all oil and gas operations, including the operation of the gathering system. So therefore, due to that, the system went dormant. It was unable to, we were unable to sell gas to that system. And over time now, both connection ends at the endpoints of their gathering system are no longer available, and their system is in disrepair, and they're unable to use this system to take any gas to any market.
So before we leave this area, or let's talk about the remoteness again. How far, or have you done any research to tell the commission whether or not you can get to an alternative market?
As the crow flies, we'll say, we have looked at it 6 miles away as the crow flies, over some pretty rigorous topography. There's no way you could do 6 miles of line. You'd have to do many miles of line to go through that topography. There is gas sales approximately that far away.
Is that feasible at this date for you to even consider being able to bring that gas to market, any produced casing head gas to market?
Since our gathering system only moves about 42 to 55 MCF a day, it would not be feasible.
All right. Slide 6 is an overhead map of the field. It includes the wells. The red markings are for A and B category wells. The blue X's are the C wells, which are not hooked into, or we're not hooked into the Red Mesa system. There's also a mark for a couple P&A wells, which have been plugged and abandoned since the compliance agreement. And then also signifies 2 combustors, which are in place now. Let's talk about those combustors a little bit. And I'd like the commission to refer to exhibit 3, I think it's exhibit 3, which is the at least a spec sheet for the Mesner combustors. Describe those, how they came about, how you identified them, how you got them approved for use in your gathering system.
Yes. We made the decision to go with Mesco's Bossinator combustors due to their field test efficiency at 99.9%, destroying VOCs or volatile organic compounds. The use of these combustors has been 24/7, nonstop. The only time these have ever been shut down. So since 2017, these combustors have worked nonstop. And again, the reason we use these combustors, and we have 2 of them, so we have capability in case one would ever go down due to a mechanical problem. They have the capability to accept the incremental increase in gas and destroy it as need be. And you can see on the map that we presented you earlier, we have a west combustor, we have an east combustor, and that's, we took our gathering system and split it up into a west side and an east side. And it's kind of northwest, really northwest, southeast, but for the ease of calling it. We just called it east and west. And this has worked very well. The west side has about 60% of the gas volume, and the east side has about 40% of the gas volume.
All right, and these combustors, they operate at a very high efficiency, 99.9%. When you're in the field, there's a big stack on top of these combustors, it looks like. Is there any kind of heat which is associated with the process itself, which gives rise to any vapor which emanates from that stack?
Yes, sir. These units operate around plus or minus 100 degrees, 1200 degrees. So there are heat vapors that come out. But these are smokeless, enclosed combustors. Nothing gets out of them. Everything that goes into them, due to the patented process these combustors have, 99.9% of the VOCs or the natural gas is destroyed.
You mentioned that there's a continuous pilot light mechanism. Is that right for the?
I didn't mention it, but I should have. But yes, there is, and it works very well. Like I said, these things have worked 24/7 for 4 years now.
All right, very good. Let's move forward to talk about. And the reason you brought these combustors online was because the market had gone away because of the decommissioning of the Red Mesa gathering system. So you needed to do something under the compliance agreement to basically destroy the gas. Is that right? That you were going to otherwise have to flare or vent?
In unification with the commission, yes, we came up with this plan, and it's a good plan.
And how did you go about getting a permit to incorporate these combustors, or was that problematic?
We had to go through the EPA to get a permit for these, due to the fact that even though we're on public lands, we're within the tribal boundary of the Southern Ute Indians. And so fee lands, they're private lands. I shouldn't say public, private lands, fee lands. And they did not come under the reservation proper, but it was within the tribal boundary. And therefore, that brought the EPA in as the permitting source. We also talked with the COGCC, the Colorado Public Health. We also, all of those people were copied on this, the Southern Utes, La Plata County. Everybody was kept informed of what we were planning on doing.
Let's move forward to slide 7. It's category A and B wells. It basically gives description as to the number of wells and gives rise to the average oil production from the well, and also the MCF casing head gas produced. Is that right? 5 cubic feet of gas is eventually emitted from the combustors. That's because there's a 99.9% destruction efficiency. Is that right?
That's correct.
All right. And the amount of gas then, which is emitted from the combustors, just so the commissioners understand the volume, it's equivalent to about 2 refrigerators. Is that right?
That's correct.
In space. Okay. Let's move forward to the category C wells. The next slide is H. It's 9 wells. Of course, these wells again have been venting because there's not a combustor which is available for these. Could you maybe more thoroughly describe why a combustor is not an option for these wells?
The volume on these wells is too minuscule to have that type of operation. The C wells make about 4.3 stock tank barrels per day of oil and around 1.36 MCF of gas.
All right, and that's about the space in a 12 by 13 residential bedroom, right, per day?
The daily amount would fill a room about that size. Yes, sir.
Okay. I'd like to just move forward past a couple of the next slides, moving forward to a conversation, or at least a discussion, as to how we derived the I guess it's slide 15. Anticipated production analysis. That talks about the GOR that was devised for both category wells. Mr. Campbell, 15, yeah, 15. It's up. I'm at 14. Here we go. 15 is there now. Yes. So looking at that slide, you reach the GOR for both fields, which gave rise to the MCF that you've already described that was produced as casing head gas for both category A, B, and C wells. Is that right?
Yes, sir, that's right. And we came up with these numbers back when we did the work for the compliance agreement. We came up with estimated volumes using our sales data on gas and having our production data that we file with the commission as far as oil. We comboed those and came up with an aromatic mean GOR ranging from 1.28 MCF per stock tank barrel to 1.7 MCF per stock tank barrel. So that's how we came up with 32.6 average production stock tank barrels per day, that the MCF per day would be 42 to 55 MCF per day.
And you've prepared an exhibit 1. We don't need to go
Mr.
through
Wells,
that, but
can I
that actually is
interrupt?
a table of those numbers that you use to reach that mean weighted average
Mr. Willis,
for GOR. Is that
Mr. Willis,
Yes.
you guys are
Yeah.
freezing and we're not hearing all the testimony, which makes your case in chief difficult to understand. I wonder if you might turn your video off and that might make your audio a little better.
I've turned the video off. Does that make it any better? Can you hear me okay?
Yeah, that actually does seem to make a difference.
All right, well, and Scott, Mr. Campbell's going to turn his off as well. Maybe that's somehow interfering with things.
Okay, let's give it a shot again. You might want to start back on the testimony about the anticipated production analysis so that we can make sure we've heard everything.
Thank you, Chair. I appreciate that. This slide, slide 15, describes the anticipated production analysis. It works hand in hand with Exhibit 1, which is in the exhibit pack, which is tabular, and a tabular exhibit. And could you describe to the commission again how you use the estimated gas volumes from the compliance agreement coupled with the oil production from each well and giving rise to the GOR?
Again, we referenced gas, the volume of gas produced per day, a low value and a higher value. We had a range between 1.07 and 1.47 MCF a day from our gas gathering system, which at that time was the category A wells. We then used recorded production data in oil and stock tank barrels per month and came up with a gas oil ratio range for each well, and then subsequently for the arithmetic average of mean average of those wells ranged between 1.28 MCF per stock tank barrel and 1.70 MCF per stock tank barrel. And that calculated with the average daily average oil production that is listed there. We divided it by 30.43 days per month. We came up with 42 MCF and 55, a range of 42 to 55 MCF per day that was produced associated casing head gas from the solution gas drive.
All right, and that's the A and B wells. And then when you incorporate the design destruction efficiency from the combustors, which are in use, that gives rise to approximately 42 to 55 cubic feet of gas, which is emitted from the combustors. Is that right? That's correct. All right. And that's enough basically to fill two regulation size refrigerators.
Atmospheric conditions, it is, yes.
At atmospheric conditions. Thanks. And you did the same type of analysis for the category C wells. Is that right?
Yes, sir, we did.
All right. Don't mean to have you step through that again, but could you just talk about, or at least give the result to the commission as to what GOR is, and then what your estimated gas production daily from the category C wells?
Using the same method to calculate, we do have 7 wells that are too small to measure by conventional means, and we used 0.1. That's about where you can start measuring gas accurately, 0.1 MCF per day, and we just assumed that on those 7 wells, and we came up with the GOR weighted basis on well by well production of about 0.317 MCF per stock tank barrel. And with the daily production of about 4.3 stock tank barrels per day, that resulted in a 1.36 MCF a day of gas being associated casing head gas.
Okay, and once again, that's about the size of a 12 by 13 foot residential bedroom at atmospheric conditions. Is that right?
Yes, sir.
All right. Thanks. That steps us through the GOR. What I wanted to talk about was in looking at and devising the GOR, we used some historical data. You talked about the sales to the Red Mesa system as a basis for the amount of gas. And that was from 2011 to 2014, I believe, are the dates. And then you also used the oil production from the COGCC website for the wells back in 2014, 2015. Is that right?
Yes, sir.
Now, does that, the fact that that was 6-7 years ago to present day, do you expect to see a significant adjustment in the GOR over what you devised historically versus what is actual today?
What we're seeing today is the same as was 6 years, 7 years, 8 years ago. These are very mature wells in their well life. They don't change a whole lot. Well, we see a slight decline in oil. We also see a slight decline in gas.
Let's move forward then to some letters which were presented, and those are Exhibit 4 in the exhibit pack. I've also put them on the slideshow at 24, I think is where they start. And there's 2 pages of them. And what do these letters, or who are they from, and how are these letters relevant to Williford Resources?
Well, years ago, previous operators agreed to let landowners have domestic taps from either wells or separator. They allowed these landowners to heat their homes, their barns, whatever they had, whatever they could use on their homestead. They've heard about what's going on with us and the possibility that we could be shut in. And they have concerns about heating their homes, providing for their stoves, the gas for their stoves, just a number of things, water heaters, everything they have. And they have concerns over losing this ability to use this gas. And most of them are have one that's 80 years old, one that's 75 years old, one's 70 years old, and one's 65 years old. And they state in these letters they would really hate to lose that. They consider us a good neighbor. We try to be a good neighbor to everybody. And I get along with these people personally, and I would hate to see them lose this also.
There's also a representation made in the application in the PowerPoint presentation with regards to a study which might, or which has been initiated to figure out what you can do with casing head gas from the category C wells. Could you describe that to the commission?
Well, it's pretty early on, our studies. We really have a hard time doing anything with the small amounts of associated casing head gas from the C category wells, especially some of them don't even have enough gas to run a prime mover gas engine on the pumping units. Of the 9 wells, 6 of them are on gas engines, 3 of them are on electric due to the fact that they don't make enough gas. So as far as category C wells go, we would anticipate, at least currently, still venting the 1.36 MCF.
Okay. But is it possible to perhaps look towards re-injection as a project, maybe gather some of that gas and put it back into the ground and maybe have it produced from adjacent wells? Or would you like to study that?
No, we'd like to study it, especially on the A and B wells that we have. We have a gas gathering system that is connected, and we can connect the east side and west side back again in relatively short time. We could look at the 42 to 55 MCF, possibly re-injecting that gas, probably at a single point.
All right, but that would be in lieu of combusting, right? Because you're combusting now and giving rise to just 42 to 55 cubic feet.
That's
Which
correct.
is a very small amount.
That's a very small amount. And like we mentioned earlier, that only results in 42 cubic feet to 55 cubic feet of gas after combustion.
Now, you touched on this a little bit when you talked about the domestic users. If the commission were to order you not to vent or combust gas, and the fact that that would adversely affect them and be a hardship upon them, what would it do to your business?
Well, it's hard to have an oil and gas business when you cannot allow to produce the oil. You can't produce the oil without producing the associated casing head gas.
Okay. And if you weren't allowed to produce that associated casing head gas, would your business, at least what you do in Colorado at Red Mesa Field, would that likely just go dormant? Perhaps never give rise to any recoverable oil reserves.
Yes, sir. That's
All right.
exactly what mine
Excuse me just a minute. I'd just like to check with Mr. Campbell if there's anything I missed with regards to Mr. Hearn that he needed to talk about. Mr. Williford, I'm sorry. Mr. Hearn. Why don't we just wait on those? You know what I'd like to do is just, I have a summary of at least Mr. Hearn's testimony, and I know that this is this stuff. I think we should leave that alone right for now. Just wait until it becomes an issue. So thank you for your patience. I just had some closing remarks or some summary remarks with regards to Mr. Williford's testimony. This field has been operating since about 1980, I think, is when the development occurred. It was, a driller who was at the time doing all he could to pull resource out of the ground. There has been venting which has occurred without regulation over the years. There was a gathering system which was put into place, which eventually caused the gas, or resulted in the gas going into the Durango market to supplement other gas sources there to be used by Durango. That system is no longer in place. It's not a viable system right now, and it will likely never be a viable system. because of its dormancy and the fact that it's fallen into disrepair. So if Mr. Williford is going to produce these wells, he needs to do something with the amount of casing head gas which is produced. The commission allowed him to do that under the compliance agreement by utilizing a combustor for the A, B, and C wells where gas production is more prevalent, and they weren't the wells weren't too remote. The gas C wells were allowed to vent. There was a change in the current because of Rule 903 and the stated rule saying that venting and flaring of gas was to be prohibited. And if you took exception to that, you could come back to the commission for a variance. And that's what we're doing. Mr. Williford got a cease and desist order basically from the director saying the compliance agreement was no longer effective. And he's before you now requesting an opportunity to continue to produce his wells under basically the same requirements that were in the compliance agreement, to where he would use this very efficient combustor to destroy most of the gas from the category A and B wells, and that he would also be able to vent gas from the category C wells, so he could continue to use the oil from the right. And therefore, there's in granting this variance, there's no net adverse impact, which is a component of getting the variance approved. I think that summarizes the technical case fairly well. He's looking again for permission from the commission to continue to vent and combust the wells as he's talked about. He wants to do it for up to a year so he can continue to study alternatives, report back to you, and if he needs to come back to get some type of extension, he would have to file an additional application for the variance, for an additional variance, if that's what the commission were to deem to be the most provident way to proceed under this application. Mr. Campbell doesn't have anything else. He's shaking his head. I appreciate the patience and tolerance of the commission with regards to the technical issues or concerns I have. Mr. Williford is here to answer any questions you might have with regards to his technical presentation. So Chairman Robbins, I just defer back to you.
Okay, thank you for the presentation. This time, commissioners, I believe that the witness and or the attorneys are open for questions from the commission. I'll start a couple of questions. Just historically, Mr. Williford, do you know why the Red Mesa gathering system was shut in or required by commission order to no longer be effective?
Yes, sir, I do. Would you like me to expound on that?
Yes, please.
I want to say in 2015, Red Mesa Holdings declared bankruptcy due to they were just not making a profit. So they were owned by a larger company, Madison Capital. Madison Capital just decided I think they cleared Chapter 7 and basically went through bankruptcy proceedings for that company. Red Mesa was eventually the assets from Red Mesa Holdings was sold to Mr. Tom Stover. Hoshi and Adam, I believe, were the two companies involved that he had. And I don't know how much you want me to go into depth, but this individual is not supposed to ever operate in Colorado again. And he had a bad reputation for operating in Colorado and had numerous fines that he'd never paid. Somehow he got to operate these wells, or at least got control of them. I don't know if the commission had a whole lot they could do against that since it went through a bankruptcy court. I'd have to let the lawyers argue that one, bankruptcy lawyers probably, but those people started operating in an illegal manner, and that's what prompted that hearing, and that's what prompted them to shut everything down. The commission to do that.
Okay.
Do you want the system now? The system used to go to, like I mentioned, Durango proper. That end of the system was cut off by the damming up of Lake Nighthorse, I believe it's called, in Durango. The locals call it Commie Lake. I don't know which it goes by, but I think it's Lake Nighthorse. That Atmos said they're not going to go, it was too far to go around the lake and reconnect the system, so they had no interest in pursuing that. They were the buyer that provided Durango with the gas. The other system was Red Mesa, Red Cedar, Southern Utes Gas Company. They have since converted that system to a water disposal system, and it's not available for natural gas transmission either. So in that meantime, that this gathering system has gone dormant, lines have been uncovered. There's holes in the system. There's no compressors, rusting away, and it's just in total disrepair and cannot be reused because it has no end markets to take the gas to. And that's basically the Red Mesa system and why. But the reason it was shut down was due to non-complying operators.
Okay, thank you for that. Mr. Williford, what actions, if any, have you taken to try to address the venting and flaring since January 1 of 2021? And I asked that because there was a kind of a 1-year grace period, and you're now asking for an additional year to address certain concerns. And I'm trying to figure out what actions, if any, were taken by your company during that 1 year.
Well, we continuously monitor if there's new gathering systems that come in place. So that'd be one thing we would always do. I have to go back in time before that date. Back before we even put combustors there, we entertained good in business with La Plata Electric Co-op in trying to use the gas to generate 3-phase electricity. And their staff really liked the idea. I liked the idea. We met, we had a presentation. The board did not like the idea, and they completely said they did not want to do that. So that hasn't changed. They're still the electric provider there. I don't think they have interest in doing it. And so that would be something I would have looked at, but it's already been looked at. So I can say I've done that. Other than that, I know of no use for the gas off the Category C wells. Then 7 of those wells have gas that's too small to even measure, and the 2 that do are just almost, it'd be economically unfeasible to hook them up to the system. And and right now I'm looking at combustion is, I know it's 99.9% effective. I know of no better use from that gas from that gathering system than to be combusted at this time. I would like to explore options, maybe a gas gathering system will come available. We're a pretty remote area. I don't know of any opportunities coming up, but I would sure entertain them if they did.
Fellow commissioners, questions for the witness? Commissioner Gonzalez?
Yeah, thanks, Chair. I've got a couple questions to just kind of clear up some things in my mind from what I read in the materials and what was presented today. So I'll kind of dive into some of those. We've talked a couple times, or you guys have talked a couple times about 99.9% effectiveness for the combustors for VOC destruction and 98% effectiveness for hydrocarbon destruction. And I guess I'm not quite sure how to differentiate those two factors. In other words, what's the difference between VOC destruction, hydrocarbon destruction, as we think about that from the combustors?
Yes, Mr. Commissioner, I'll address that. The 99.9% is VOC, includes the natural gas. The 98% number we referred to is what permitting requirements are. It's minimum destruction capability of the combustor would be 98%. That's what you have to at least have to have proper combustor out there. So these combustors are more efficient than the 98% requirement that is required.
Okay, so if I look at that, I should be thinking about this, that combustors basically will account for 98, at least 98%, but up to just shy of 100%.
That's correct. Yes, sir.
Okay. I want to move on to another question about volumes, venting volumes. It's been referred to as de minimis volumes or minuscule volumes, and there's been some good testimony on that today to help me understand that. But I kind of like to bottom line it here. What's the reference for what is minuscule, what is de minimis, right? Compared to what?
All right. I could compare this like we used in reference to the refrigerators. 2 refrigerators full of natural gas at atmospheric conditions are as a result of going through the 99.9% efficient combustors. That's minuscule amount of gas. For a daily volume to only fill 2 refrigerators, that's definitely minuscule.
Yeah,
I would also include the venting wells. The ones that are too small to measure, the ones that are less than 1/10 of an MCF a day, that's pretty minuscule amount of gas. It's hard to even run a prime mover gas engine on a pumping unit with those volumes of gas. It's when those wells, let's say the wells break and we have to pull them because the rods broke, the rods that go up and down in the pumping unit break, and we have to get a pumping unit out there. When those wells go down, and before we can get a pumping unit up there, we have to go buy propane to start those wells with, because there's no gas. There hadn't been producing any gas. So the solution gas has disappeared. The associated casing air gas is 0. And so that's how small volumes these wells make.
Thank you, Mr. Williford, for that. Hey, Chair, point of question here. Are we going to be able to ask staff, I guess some of the technical folks on staff? I had some other questions that kind of tie along to this last question about volumes and quantification. Is that an opportunity we have here today?
I believe so.
Okay.
I believe next steps would be to recognize staff after we're done with this witness. And obviously the applicant would have a chance for a rebuttal after staff presentation.
Okay, thanks, Chair. I'll circle back on that when that time comes around. Mr. Williford, I got a couple more questions for you, if you don't mind.
Yes, sir.
Let's see, I'm going through my notes here. Okay, so I'm curious about the exploration. I guess it's my understanding that the beneficial reuse of gas is the only available remedy to Williford as an alternative to venting, and that a gathering system is not feasible because of what I understood was geography. Are there any other reasons, volumes, line pressure, for example? I think we've heard a little bit about volumes as to why a gathering system would not be an option.
There are no pressure problems. We operate in the wintertime, we operate our gathering system at 4 to 5 pounds. In the summertime, it's about 3 to 4 pounds. This pounds, PSIG. It's very low pressure. It's mainly right of way, boring county roads. They don't allow us to cut through county roads in La Plata County. So it is very expensive to do that work. Permitting at Ward Road Bore in La Plata County is pretty tough due to their land use act they have there. Topography is a reason. Economics, of course, as you mentioned, is a reason. And getting land on the right of way are all limiting factors to wells that produce very small amounts of gas being hooked into the gathering system.
Sure. And I think what we're talking about here with the existing gathering system takes all your Class A and Class B wells and then takes them to a centralized combustion facility. And I guess what we're talking about for kind of what would prevent venting altogether would be to put it into a sales line. And that's what we're talking about has this, I guess, these hurdles from an economic perspective, from a geographic topography perspective. Is that right?
That's correct. Yes, sir.
Okay.
And it's 2 combustors. It's not just one. We have a east and west combustor.
Okay. And so I think you talked about this kind of towards the end of your presentation. I apologize if I missed the full explanation, but what's been done in terms of exploring the viability of this gas injection possibility?
Well, we're talking about the gas from our east compressor, east combustor and west combustor systems, re-injecting that gas. There'd be somewhere the gas runs from about 42 to 55 MCF a day. And all we've talked about is we have to have a point, one well where we could re-inject that gas. As far as doing any expert consulting work, we have not done that yet. It's probably something we need to talk about with staff a little bit. That has not been breached with staff there at the COGCC, and be happy to discuss that with them.
So Mr. Williford, in your petroleum engineering expertise, do you think that the prognosis for the viability is positive, right? Do you think that this gas reinjection is going to be a truly viable option just at first glance?
If we call it a viable option for another way to keep the back gas from being vented to the atmosphere or going through combustion processes, yes, it would be a viable thing to do. Do I think it's going to increase reservoir productivity? The small amount of gas we're talking about, I do not believe is going to do that. Not in enough to be an economically feasible project on its own bearing.
Sure. So it sounds like the reinjection is more of a it may have some interaction with with the product that's in the ground, but kind of more of a storage than really enhanced recovery. Is that correct?
Yes, sir. That's correct.
Okay. Thank you very much, Mr. Williford, for engaging with me on that. I've got a couple of questions I think would be best directed for your counsel. And the first one is, in terms of this no net adverse impact to public health, safety, welfare, the environment, and wildlife resources, it seems to me that impact was gauged against the status quo under the compliance agreement. And I'm curious, if we exclude that and we just take it kind of on its own merit, how has the applicant kind of met that burden in proving that there's no net adverse impact to public health, safety, welfare, the environment, and wildlife resources?
I guess my response to that is, and I hear what you're saying with regards to status quo under the compliance agreement, right? That would be part of the request here in the interim until we could maybe undergo this study to see if there's something else we can do. it is what it is. And Mr. Wilford is telling you that the only way today that he can take care of this gas which is produced is to continue basically under the terms of the compliance agreements with regards to combustion and the venting. But he continues to try to think about and be creative with regards to any viable options he may have. So no net adverse impact. It's such a minuscule amount. And this is the other thing I wanted to talk about, Commissioner Gonzalez, and it's not to trivialize the amount of gas or emission which is being put into the atmosphere. But I was just trying to think about different words for small amounts. The amounts are very small, and they're minimal, but they're necessary with regards to producing the liquid that they're producing in the field. So I don't know if that gets to your question. I wish it was something that could be more measurable, but it's not.
No, I appreciate that. Thank you for that response. So if a variance is granted, and I'm thinking about kind of appropriate timeline for seeing progress towards eliminating, the anticipated venting, if that's a possibility. It seems like that may not even be, obviously it's a possibility, but it seems really like the only option on the table now is re-injection. And so do I have that right? It's basically re-injection, or we're going to see you guys in a year looking for another variance?
I think it's always possible to, there may be other uses for it too, maybe other domestic taps. I don't know if that's preferred by the commission, but perhaps there are other users that could maybe benefit from this. Perhaps Mr. Williford can see, or maybe, I don't know if he advertised for it or just what. I don't think he wants to do that necessarily. The reason why he's got these domestic users in place now is because he basically inherited them from the initial operator. From what I can understand, they've been in place for decades.
Yeah. Go ahead.
So I think he's in a real hard spot geographically at the onset, and then there's also the things that exacerbate it with regards to topography and all the other things that he testified to, which limits his ability to get the category C well gas to his combustors. It's just not practical. And so the only other option identified right now is the venting piece.
Sure. All right. That answers my question. And I appreciate the time, appreciate the presentation, and the engagement on my questions. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. I've got a few questions. I think for initially Mr. Wilford, perhaps for council after that. Appreciate the presentation and the submittals that were provided. I just want to make sure that I understand. So you did understand and acknowledge that the 900 series rules do prohibit venting and flaring of natural gas produced from any completed well, except for, under the limited circumstances in 903D, A through F. Is that correct?
Yes, sir.
Okay. And you understood the timelines associated with that when that rule was promulgated?
I understood. I also was under the compliance agreement at the time. I did not receive notice that the compliance agreement was going to be vacated until December, almost around Christmas time of 2020.
You were aware that the rules had changed, and in those rules it addressed previous operations?
No, sir, I was not aware of that.
Okay.
I was under the impression the compliance agreement would keep on going.
Okay.
I spent a lot of money getting compliance for that compliance agreement, and it was working well. Again, I did not understand that. No, sir.
And as part of the implementation of the rules, and in utilizing some of the limited circumstances that are available in the 900 series rules, there's kind of a requirement or an expectation to explore different options for beneficial use of the natural gas that's associated with your operations. And it's a little bit of a follow-up from Commissioner Gonzalez's question and Chairman Robbins' initial questions. While I understand that there has been some recent exploration of the utilization of that natural gas for injection, perhaps there was some general exploration of whether or not it was feasible to utilize the Red Mesa gathering system. And I'll have a couple of additional questions about that. It does sound like there was some conversations with La Plata Electric Co-op regarding utilization of the natural gas for electricity generation. I guess one of my initial questions is because we have to make a finding, or we have to understand you have a burden to prove that there was a good faith effort to comply. And I'm struggling here a little bit with the timelines and the timeframes as far as exploring other beneficial utilizations for this natural gas that's being produced from your operations, except for in a very recent time frame. So can you explain to me other options that you explored or discounted or have gone further into depth over the time frame since the 900 series rules were put into place to today, to help me understand how you made a good faith effort to comply with the rules?
Yes, sir. I'll be happy to do that. We've explored, again, generating electricity was put to bed earlier, so we did not re-step those steps again. Maybe I should have. I don't know. I don't believe that's a feasible deal from the way La Plata Electric Co-op voiced their disagreement with it the first time. I've looked at what other people have done with stranded gas. Some people have been able to go into the Bitcoin mining. We don't have enough volume of gas to allow for that. My initial contacts with a couple of people said they were looking for a lot more gas than what I had available. So that eliminated that. And that's been pretty recent that I've done that. In the last 6 or 7 months, I've done that. So other than most all the wells that are on pumping unit, of the 37 A and B category wells, 20 of those are on gas prime mover, 17 are on electric prime mover. The ones that are on electric were on electric mainly for noise. People complaining about, I can't sleep due to your pumping unit making too much noise with the gas engines. So if power was available there and we had that, we electrified some of those. Some of them are electric because they don't make enough gas to run a gas engine. So that's why we have, I prefer running gas engines. It's far cheaper to run a gas engine other than the maintenance on them. It's far less expensive than burning electricity on electric motor on a prime mover. So we're really pretty much, if chance comes up or someone moves out and the house is vacated, maybe I can go back to gas engine on the pumping unit. Maybe that's one way to use a little bit of gas. but that's the only thing. We have no heater treaters out here. We have one separator. If we have the, if we don't really need any, so we don't produce any water with our oil. Our oil, this is a low cost operation. We have low volumes, but it's low cost, and we don't have to chemical treat for water or dispose of water or any of these natures. And now, if we get a casing leak or something we have to repair, yes, we get some water and we dispose of that water. But I have no place to sell the gas. I could possibly, I've had a couple of other domestic owners talk to me about hooking up to my gas system since I'm not using it. But I have not done that. I am happy to do the folks that I've done, but if you require me to do that, I would do it. I mean, but that's, I think I don't like that situation. So other than that, I'm running out of ideas, but I do have a re-injection idea. I also know that this could possibly be water flooded at some time in the future. That doesn't help me with natural gas flow. The recoveries from here are just from solution gas drive reservoir. And there's plenty of oil remaining in place, at least in the Dakota Formation, to maybe substantiate a water flood at some time in the future.
If I could, Commissioner Messner, if I could just tail in with a couple comments. This is Rob Willis. And in regards to your query under satisfying Rule 502C1 and the good faith effort, I think it's important to look at not what he's just done in the last year since the rule's been enacted, but to look at his course of conduct, which he's given, I think, a very good description on, to try to get some kind of alternative for this gas instead of venting any gas. But despite those good faith efforts, he's in a position where he's unable to comply. And I think that's part of the rule too. And as you're considering this, he continues to be receptive to alternative ideas, but he's explored many ideas, which continue to be potential ideas, I suppose, if something were to change in the market conditions or with the commodity pricing, making it more attractive for someone to come in and assist his transportation, or to look at powering something that he can throw into the grid. But those options are not available to him. I just wanted to kind of bring that point with you, if I could, Commissioner. Thank you.
Thank you for those responses. So I want to ask a couple of questions about the Red Mesa gathering system. As my understanding is, based on your testimony, that you've made a determination that that's not a feasible gathering system. And I think we've gone through the history of that. I also think that my understanding is that it's an idle system at this point, with certainly some maintenance issues associated with it. Is it possible to update that system and utilize that system as a way to capture gas and move it to a sales line in the future? And the decision, let me start there. Is that even a possibility?
No, sir, it's not a possibility.
And why?
I can explain it if you would like me to.
Yeah, that'd be good.
Right now, there are no end systems that could be connected to that system. There are no sales points. There's no one coming to grab 42 to 55 MCF that could go through. I would say after our gas goes through that system and their system, they would get very little gas, because the efficiency of that system was not very high when Red Mesa owned it. It was not an efficient system. It leaked gas. I would call it severely. I was always getting discounted on sometimes by gas leaks. Not all the time, but sometimes. I you're trying to take gas from my gathering system, going through another series of gathering systems that aren't all connected anymore, through 7 to 12 miles of pipe, and we're only moving 42 to 55 MCF a day. That is not even, no one would reasonably conceive that. Now, if they're out there buying gas from other people, yes, but just to rebuild this, it's kind of like me buying a house and taking it down to studs. You might as well have built the new house, is what my experience has been over the years with my wife. You would be better putting a whole new gathering system in the ground.
And I believe your testimony is that, while putting a new gathering system in, could be economically infeasible. There is the ability to access a sales line approximately 6 miles away as a crow flies, understanding that that is not the way that pipelines run. Is that correct?
That's correct. Yes, sir. Especially in that kind of terrain.
And was trucking ever considered?
Trucking the gas? I guess we're talking about compressed natural gas. I don't know how we do that for 42 to 55 MCF.
Okay.
I don't think there's a process that is available to me. I know there's not.
Okay. I'm asking these questions because I'm trying to understand the analysis that was done as far as the different options that may be available to you to utilize this natural gas, because right now, at least I believe what I'm hearing in testimony is that you're anticipating one option that you're just currently exploring, which is the injection. Otherwise, while this variance request is for 12 months, without being able to come up with a viable beneficial use of this gas, we can expect to see this variance request again in front of us in 12 months to continue venting and flaring. Is that a fair assessment?
Hold on.
Mr. Chair, if I may be heard on that issue, this is Mr. Campbell.
Go ahead.
I don't know that it is a fair assessment, Commissioner Mesner. He has explored numerous options for, I'm sorry, we're getting feedback here. That's why I'm pausing. Over a lengthy period of time here to, as we put it earlier, build a better mousetrap. He is, in our view, exactly the kind of operator to whom you should grant a variance. And he's still working at these issues. And there is a demonstrated history of good faith performance here. The volumes are so minimal, as he stated, that they can't even be measured in many respects. And he's not asking for a permanent variance. He's asking for the opportunity to explore every opportunity he can. And I don't believe he's saying that the only opportunity he's going to be exploring is re-injecting. But it appears to be the best idea right now. And the fact that it might not work out and we might be back in front of you in a year, respectfully, we don't think is relevant. That's how this process should work. Let's have a collaborative approach to this. See if we can't work things out in a way that works for everybody, where everybody accomplishes their goals. And if we can't get there, then yeah, we think we deserve an opportunity to be back in front of the commission discussing these issues. And given the volumes that we're talking about here, what have you really given up? Respectfully, nothing. there just doesn't seem to be any incremental harm.
So last question. Yeah, I think my last question is actually, I'll hold that for staff. So appreciate you answering my questions.
Commissioner McGowan?
Thank you, Mr. Chair. And thank you for your presentation today. And thank you to my fellow commissioners who asked many of the same questions that I had on my little sheet as well. I think for me, it sounds to me, or I'm feeling like the variance request, the year extension, I'm thinking we're not going to see much happening with your category C wells, given what you've been saying about the feasibility of being able to do something alternatively with the de minimis amount of gas that's being emitted. Would that be fair to say that in a year, it's almost like the variance is for an extension for a year for the A and B, but the C, we don't really see other options?
Right now, I have no other options on the C wells.
Okay, thank you. So I'm going to ask a hard question. Is your business still viable if the C wells were shut in or P&A'd?
I would hate to lose 4.3 barrels, stock tank barrels a day of production.
Okay.
I am currently not producing those wells. Because we were venting, I made the election on January 15th not to produce those wells. I hope the time they've been shut in, they have not been harmed. These wells do have a history of not being able to come back to full production after they've been shut in for a while. This is a history that previous operators experienced before I experienced it also.
Okay, so
the gas off the, I've stressed this, there's so little gas off the category C wells. There's 2 of them that make any significant amount of gas. I don't only call it significant, larger minimal amount of gas that just are not going to be able to be hooked up to the gas system.
I completely appreciate what you're saying, and I appreciate your response. And it sounds to me like you did not participate in the commission's mission rule change and the conversations that we had. Well, if each individual operator though has de minimis or very small amounts of emissions, once we start adding those up over time, it's not de minimis anymore. And so I think that's why the commission was saying we don't want to see any more venting at all. Flaring is a second choice, but not one that we want to see either. And we prefer that we saw beneficial use. And that's the goal, to try to minimize waste or eliminate the waste and or emissions that add up over time for the state. And so I'm also wondering, are you the only operator in the area who's in this, I'm going to call it a pickle? And if you're not, have you explored working with some other operators in your area to figure out if you could pool your natural gas so that it would be more attractive for other uses?
I am not the only operator. I'm the only one that has a significant number of wells. There are a couple of other operators that have 2 wells, 3 wells, and it would not be very easy to connect those wells since I have a hard time connecting. They're located a distance away from my gathering systems. And I haven't been approached by anybody that seems to have a problem other than me. No one else seems to be shut in. They're rocking along. So there I am. I spilled the beans on my brethren out there, and I shouldn't have. But not sure what's going on. I know that I had an agreement with the commission, compliance agreement, and that probably was with their main concern in Red Mesa area of Colorado. So they targeted me. Compliance agreement is a very good agreement. It does work. I understand y'all want me to do something else with the gas, and I just, I have very few options.
Mr. Chair, may I respond briefly to Commissioner McGowan?
Yes.
Thank you, Mr. Chair. Commissioner McGowan, we are sensitive to those incremental concerns. And it's one reason why we're asking for a 1-year variance. It gives us the time, again, to see if we can build a better mousetrap. It gives you a manageable amount of time to get your bearings on how big an issue is this statewide? How many more variance applications are you going to see? And although we would concede that every grant or denial of a variance has some precedential value, each case is going to need to stand on its own merits. So it's not necessarily true that granting a variance here is going to result in the grants of variances elsewhere. So we acknowledge that's an issue, but we do have this variance process, which clearly the commission contemplated as a mechanism to provide some relief when merited. And we think in these circumstances, for at least a year, it's merited, and he's demonstrated as such.
I appreciate that insight, and we have the variance for a reason, and operators should use it when they think it's appropriate. For me as a commissioner, though, I think that I need to ask myself, what's going to happen between now and next year, given what you shared with us and what we think is feasible and what our rules say, right? Which is no venting, no flaring. And so I'm trying to figure out what is actually feasible with all of these wells and the different categories and what you've presented today. And I really don't see that the category C wells are going to change much, or there's many other option for them except for venting. And that seems contrary to our current rules. I'm very appreciative that the A and B might have some other beneficial options that are still being explored. It seems to me like the obvious ones have already been visited, but I don't want to rule out that someone might have something creative somewhere that might work. And so that's kind of, I'm dealing with that right now, kind of struggling with what that looks like. So I appreciate your insight. The variance is there for a reason, and we're here to listen to those variances. So thanks.
Further questions? One follow-up, Mr. Wilford. How many homes are receiving domestic gas?
Currently, there are 4 residences receiving gas.
And is that from an A well, a B well, or a C well?
Most of them are, I would say, A and one B well. One is a separator. One is not a well. One is on the separator for the M&M number 1, 2, 3, and 4 wells, which are all A wells. That gas stream goes to a home off the separator, not off the well directly.
And explain to me why it is that the wells provide domestic gas to the homeowners. Is it, I assume that's part of the mineral lease?
Not all of it's part of the mineral lease. With Mrs. Hubbs, it's part of the mineral lease. I believe maybe with Donna Ray, it's part of the lease. The others were granted by an S&I oil corporation when they drilled the wells as part of their settlement for damages, I believe. because they did not have a market for the gas, they were using that to trade with the homeowner. Or
So
the
that would
homeowner
be,
using that to trade with them.
okay,
So I just honored that. As the evolution of operatorship came through, I just continued honoring the taps.
and if those wells are not producing or are shut in, does the obligation to provide gas go away?
It has not been an issue. Fortunately, like the separator tap, there's 4 wells to there. So one of those wells is always producing. In the other circumstances, I have brought propane to them to use overnight until we could get it back going. I mean, I just felt obligated to do that. That's nothing in writing, nothing. It's just a personal choice.
Do the 4 homes that receive domestic gas have auxiliary propane abilities currently?
I think most of them do. I can't really vouch for that. I don't know. I know 2 of them do. I don't know about Don Ray. And I'm not sure about Mr. Ray.
Okay, thank you. Commissioner Messner?
Thank you, Mr. Chair. I did have one more question for Mr. Wilford. I wonder if you could confirm that that the mineral owners that are associated with your operations have been compensated for the vented or flared gas that has occurred up to this point, and that would be in the future associated with this variance, should it be approved?
I pay them exactly the same much I get paid. That's per our agreement.
So they do get compensated whatever their
They
required
did,
amount
they
is.
did when we sold the gas, we paid them their share of the royalty. Yes, sir. But we aren't selling the gas now.
I understand, but so are you calculating the gas that is being flared or vented and providing compensation to the mineral owners for that?
No, sir.
And do you contemplate doing that as part of your variance request?
No, sir.
Okay, thank you.
Further questions? All right, thank you to the witness and the attorneys for the presentation. It is 10:48. I suggest we take a short break and then we will hear from staff. Let's return at 11 a.m. 11 a.m. Got it recording again. Mr. Campbell.
Mr. Chair, if you would give me the opportunity, brief opportunity, just to address Commissioner Mesner's questions to Hearn Williford right before the break.
Please, go ahead.
Thank you, Mr. Chair. Commissioner Mesner, we would anticipate, given the vintage of these leases, that the oil and gas leases would afford Hearn Williford the right to use the gas on site and or to vent or flare it without having to pay royalty. In all fairness, I don't know that for a fact. We haven't looked at the leases, but that would be our expectation. But I just wanted to leave you with this other thought, and it's regardless of what the lease say, it's our belief that those royalty owners would prefer to continue to receive their royalty checks, on the much greater oil value and put money in their pocket today, particularly when you take into account the time value of money and investment opportunities, rather than forego, or rather than fuss over a couple dollars a month on these minuscule gas volumes. Now, again, I don't know that, But that would be our expectation just based on our collective experience in the industry. So, thank you.
Thank you, Mr. Campbell. Do you have anything further in your
Do we?
presentation?
Oh, no. No, Commissioner, or Mr. Chair, we don't. Thank you.
Okay. Then procedurally, what we will do is we will recognize staff for their whatever presentation they're planning on presenting to us. Mr. Campbell, I will recognize you and your client for any rebuttal that may develop as a result of whatever we hear from staff. And we'll also recognize your sort of holding the point that if something comes up and you're not prepared, then we could potentially think through continuance to make sure that all of your rights are addressed. Does that sound fair?
Yes, Mr. Chair. Thank you.
All right, Ms. Rosenberg, will you recognize staff?
Thank you. At the outset, thank you for your time. My name is Kelly Rosenberg, as you know, and I'm one of staff's enforcement officers. I would like to clarify at the outset, just in case there's any confusion, my job title is enforcement officer. This is not an enforcement matter. I am not here in my capacity as an enforcement officer seeking any sort of enforcement of any alleged rule violations. One moment, I tried to give my dog a treat to stop any noises and it's resulted in whining. So one moment. Thank you. And then at the outset, I do have a question for you, Chair Robbins. My impression was somewhat that you did not want to hear any more legal argument on this topic, but I wasn't sure if that was your what you were saying earlier today. Okay.
You have free reign in terms of what it is you want to present.
Okay, thank you. So two things just preliminarily, staff would like to clarify two legal arguments that were raised earlier today. But first, here today, staff is here to discuss two topics for you. The first of which is that staff believes Commission Rule 903 is valid. And secondly, staff would like to provide some input regarding the technical information that Williford has provided. Staff is not suggesting that it has any vested interest in the outcome of this variance request. Staff is available to answer any questions you may have, and it would like to provide some input about the information that has been provided, but staff defers to the Commission regarding whether the variance should be granted. And in addition, staff does have 2 points to make from earlier today. First, staff did not argue that Williford was unable to seek judicial review of the rules because of lack of participation in the rulemaking proceeding. That is not staff's position, and it has not been staff's position. Secondly, while staff agrees that an agency can determine an as-applied constitutional challenge, Williford's application did not appear in any way to be an as-applied challenge. In fact, in paragraph 24, it says directly that the rule is void for constitutional reasons. And so I just wanted to clarify that staff agrees that an as-applied challenge can be taken up by an agency, but that this did not appear to be an as-applied challenge. Staff believes that Williford should be limited to the arguments it made in its application. It did raise some new arguments in its materials that it submitted Monday, and staff has not really received proper notice and isn't quite able to respond to those properly. Staff believes in it as consistent with what it filed in its March filing, that this is the improper forum to challenge a rule, and it is illogical to ask an agency to invalidate its own rule. Williford should have sought judicial review. It should have sought an as-applied challenge and understood that there could be a disagreement about that, but I just wanted to raise that again. And it is also just illogical to ask an agency that adopted a rule to expect to say that it did so without legal authority. Other entities with authority have considered the legality of Rule 903, including an Attorney General opinion, which is an independent legal review. And in that Attorney General opinion, the Attorney General found no constitutional or statutory deficiency in the rules, which included Rule 903. In addition, the Office of Legislative Legal Services does an independent legal review of all rules pursuant to the Administrative Procedure Act. That office has statutory authority to flag any rule for the General Assembly's review, and no rule was flagged, including Rule 903. Moreover, in its application, Williford relies exclusively on a 1955 COGCC case, and that reliance is misguided. In that case, this Colorado Supreme Court did discuss waste in the context, though, of a completely different environmental regulatory scheme and under completely different factual scenarios. And I do request that you take a look at staff's filing to get a better explanation of what those differences were. Notably, the case was not at all based on issues related to adverse environmental impacts. It had to do with whether the commission could require underground injection of gas that was being flared at the, invented at the sites. And it was an incredible amount of gas at that time too. On April 18th, Williford argued for the first time that the Air Quality Control Commission has exclusive authority to regulate air pollution associated with oil and gas operations. Again, this argument was not in Williford's application and should not be considered. Regardless, staff believes that those rules do not supersede the commission's rules. It is unclear whether the Air Quality Control Commission is the air quality regulator for at least some of the wells at issue. However, staff has not been able to analyze that appropriately. And staff again refers the commission to the relative rule opinion and the lack of action by the General Assembly regarding the rules, including Rule 903. Similarly, Williford made two other new constitutional arguments on April 18th, claiming that Rule 903 violates the Fifth Amendment of the US Constitution, and that a mineral rights lessee has a protective property interest that may be subject to a claim for inverse condemnation. These arguments also were not in Williford's application. And again, staff refers the commissioners to the Attorney General opinion and to the Office of Legislative Legal Services analysis for when considering these arguments. If the commission would like further briefing on these subjects, staff is happy to do that, but we just wanted to raise these issues for you today in our presentation. And now at this point, staff has a little input, and my role here is to sort of just shepherd this matter for staff members. I will not be able to answer technical questions, but we do have staff members who are available to answer any questions you have. And as you know, the director referred this variance request to the commission pursuant to Rule 502. And staff is providing input based off review of Williford's submitted information. And after reviewing the Williford's application, proposed order, and responsive documents to an informal request for more information, staff's input is generally that it lacks the necessary information to recommend whether the commission should grant the variance request or not. Staff is not suggesting that it has any expectation of what additional information would yield. It is not suggesting at all that it would have an opinion even at that point. But staff just wants to make the commission aware that it thinks certain information is missing for the commission. You may disagree, and staff does not object to you disagreeing with that. Staff notes that Williford bears the burden to establish that it is entitled to the variance, and that it is not staff's duty to fill in the blanks where there could be lacking information. Staff believes generally that the quality of some of Williford's provided data is insufficient for staff to opine on Williford's assertion that its venting does not result in any net adverse impacts to public health, safety, and welfare, the environment, or wildlife resources. For example, Williford relies on data from 2011 to 2014. The data submitted is unclear as to whether it represented all gas produced from the wells during that time frame. Staff believes that Williford does not properly report production for all the relevant wells. And Williford does not conduct or submit gas analyses for all the wells. Staff cannot determine how much gas is not going through the combustors as well. And for these reasons, staff would like to be able to highlight these concerns that they have for you and explain them with through any questioning you may have. And again, staff does not take a position or have an opinion about the ultimate outcome in this matter. And staff acknowledges that you may feel you have data sufficient to make a determination and even to grant the variance. And staff is not arguing one way or the other what your decision should be. And with that, staff is available for more questions. If I'm able to answer a question, I'm happy to do so, but that's the basic overview of staff's position.
Thank you, Ms. Rosenberg. Questions from commissioners to staff? Commissioner Messner, then Commissioner Gonzalez.
Thank you, Mr. Chair. I wonder if staff could expand on the Williford production reporting and the question as to whether or not they properly report production.
And I believe Diana Byrne is available to answer questions.
Okay, hold on just a sec. I
Sure,
see,
Robin.
see Mr. Leonard. I see Diana Byrne has unmuted. I believe before these folks testify, if we're doing this appropriately, we should call upon Mr. Davenport to swear them in. Seeing that we don't have Mr. Davenport, I know how to do this. If you would raise your hand, state your name and swear to tell the truth, that would be sufficient. Mr. Leonard first.
Yeah, I'm Mike Leonard, swear to tell the truth.
Ms. Byrne.
Diana Byrne, swear to tell the truth.
Great. Who would like to answer Commissioner Messner's question? Mr. Leonard.
I can take a shot at that, Chair Robbins. Thank you. Just as an example, Commissioner Messner, the diehard number 1, API number 067-05446, is in the category B wells, and they have an estimated volume of 1.5 MCF per day. However, when you go into production records, there is no record of produced gas. So it's difficult if we don't know in the production records, then is that proper reporting? And that's only one example.
And so based on that kind of perhaps inaccurate information or not producing the documentation for all production, it's nearly impossible for staff to determine how much gas is not going through those combustors. Is that correct?
And I would defer to Diana Byrne, but I believe so. I would not characterize it as inaccurate, but incomplete information.
Or perhaps inconsistent?
Possibly.
Okay.
I knew there was an in there, but I agree. Yeah.
Ms. Byrne, did you want to elaborate at all on that
It
point?
wouldn't be only the stuff that's not going through the combustors, but what is going through the combustors. Because we don't have any reported volumes.
Okay, so both going through the combustors or perhaps not going through the combustors. So there's just some
Yes.
some inaccuracies there. Okay.
Well, incomplete data.
Incomplete data. That's my first question. I'm going to hold off on my second question here for just a second.
Commissioner Gonzalez.
Yeah, thanks, Chair. And I'll kind of piggyback on Commissioner Messer's question. It wasn't one I had, but it kind of tickled something in my brain. So Mr. Leonard, Ms. Burns, in terms of the reporting, are you guys talking about Class A, Class B wells that would go through the combustor? Or are you talking about Class C wells where we've heard testimony that they're estimating because they can't really measure the volumes?
Commissioner Gonzalez, the example I gave was a Class B well.
Okay.
I can probably pull up a Class A well as well.
Yeah, I guess what I'm trying to understand is that there's no reason why they wouldn't be able to measure from the Class A or Class B wells in terms of their reporting. Is that correct?
I believe so, according to their testimony.
Okay. And then for these production records, are actuals always provided, or are estimates sometimes provided?
Mr. Leonard.
I believe they can estimate the gas. Is that correct, Ms. Byrne?
Yes, but they have to have a demonstration of how they're determining that.
Okay.
Feels like it was back calculated for the other ones.
Thank you for that. Okay, I've got a question. This is the question that I had originally. I'm curious, we've talked about these, the volumes, right? And they've been described as de minimis or minuscule. And we've had a comparison to a volume that fills a refrigerator, of which, I can visualize the size of a refrigerator, but the volume of the gas inside there doesn't really, I can't connect the impact of that. And so trying to understand, are there other operations around the state that are venting similar or greater volumes of gas? What are those operations, under what circumstances? And really, in staff's opinion, assuming the information that has been provided by the applicant here, are these minuscule or de minimis amounts?
So it's difficult if we don't have a finite measurement of the casing head gas that's being measured, and rather just classified as de minimis or incalculable or whatever. So that's throws a real wrench into it. And I'm not aware of anyone. We had some other ones that would have vented casing head gas for production purposes, and they have shut in the backside. I don't know of anyone doing the backside venting and what those measurements are. So I apologize.
Okay, and that's fine, Ms. Burns. I appreciate that. That was kind of half my question. And I guess I want to, talk about, if we assume these values are correct for the Class A, Class B wells, post combustion of 42 cubic feet to 55 cubic feet, we're talking about CF, not MCF here. To me, those volumes don't seem very large. If those volumes do ring true, are these volumes of concern as casing head gas to the agency, to staff?
No. We're crossing into the permitting through CDPHE's world to some extent in terms of emissions.
And okay, well then let me piggyback on that then. What CDPHE's role in determining allowable venting volumes, I guess?
None with venting.
Okay. And even venting post combustion?
So the piece of equipment that they are utilizing meets the requirements of CDPHE, and that piece of equipment would also have to be permitted through CDPHE.
Okay.
Excuse me.
Sure.
These wells, as stated earlier, these wells are not under CDPHE's purview.
Oh.
They are under EPA because it is within the external boundaries of the Southern Ute Indian Tribe. I mean, if you're looking for an apples to apples on another part of the state, yes, but CDPHE does not regulate the area here.
Okay. Yeah, and I guess what I'm trying to get at is one thing I'm trying to reconcile is that, you know, we built in this possibility of variance. We acknowledged it in our SBP and mission change that there may be circumstances where there are operations around the state that may very well have a very hard time, if not an impossibility, to manage their gas. And I think that's something that we're thinking about here. And so I really want to understand someone who's not I guess, as well versed as I'd like to be in terms of the impact of these volumes. You know, what does this really mean to us when we're talking about 42 CF, 55 CF, or, you know, specifically for the Class A and Class B wells, because kind of putting Class C to the side. What should we be making of those volumes in terms of the impact of those volumes?
Commissioner Chairman, if I may.
Go ahead.
You know, staff is here actually to seek your guidance on that, and that's where staff is just presenting what they believe to be insufficient data, but don't have an opinion about the ultimate outcome, about what is significant or not.
Yeah, and that's fine. We're going to make a determination on the ultimate outcome of the variance. I'm trying to understand from the experts who deal with these volumes on a regular basis what their opinion is on the impact of these particular volumes at issue. So I get what I guess, I mean, I can categorize it, right? Is this extremely low danger, you know, to almost no in terms of impact? Is this a very high danger situation? And I'm using the word danger, but I'm really trying to get an impact here. Trying to understand that. I've heard numbers. These numbers don't mean as much to me as perhaps I'd like to get an analogy here. That's what I'm asking for, scratching for.
I guess I'm struggling for an analogy. For many reasons, you know, a lot of it is based on, is this the correct amount?
And I'm asking to assume this is the correct amount just for the purposes of this discussion, just for the purposes of trying to understand, is 42 cubic feet a day, is that a big concern? Is it a little concern? What are the thresholds? Because right now our rules say 0. And we're trying to understand, you know, the impact of this variance, and specifically, you know, I'm trying to assess the impact to public health, safety, welfare, the environment, and wildlife resources as a result or an outcome, or, you know, as it relates to the volumes that we're contemplating here, knowing these volumes are only what's being presented through testimony.
So are you asking about the 42 CF a day? Is that post combustion?
That's post combustion, as we've heard in testimony and in the filed application.
I see.
The impacts of, I'm sorry, I need to. They declared there's 42 after combustion, or 42 from the sea wells.
Their testimony said that the daily venting from the Class A and B wells, of which there's 37, is 42 to 55 MCF. So that combustion brings that down, post combustion brings that down, essentially a multiplier to the CF, right? To the actual to cubic feet, right? So you're moving the decibel there because you're eliminating almost all of the hydrocarbons through combustion, as I understand it. So what they're testifying to is that post combustion, the volumes that they're venting on Class A and B wells is 42 to 55 CF, cubic feet.
So the standard versus the 1,000.
Correct.
Is that,
Mr. Gonzalez, did you also see in submitted forms though? I saw 60 also as part of submitted testimony. So just to kind of go along with like, what number are we really talking about?
sure. Yeah,
And
I saw 62.
Okay. And then when I was trying to figure out like what this meant, think I looked up something and it says that 160 cubic feet is what it takes to, I'm not, was the word, provide enough energy on a daily basis for an average home.
I don't know that still answers my question about the impact of what that volume looks like when it's vented to atmosphere. And that's still my question. I'm not quite sure if my question is understood. If I'm asking it the right way, does it make any sense? I'm seeing a lot of, kind of blank stares. So I'm happy to rephrase it as many times as I need to, but I'd really love some guidance on how you're understanding my question and how I can best phrase it in a way that I could get some expert opinions from staff in this regard. Any feedback from Ms. Burns or Mr. Leonard?
So, Commissioner, and I want to use the word small as relative, right?
Of course.
It is small, but the answer to is it significant? I believe that's for the commission to decide, isn't it?
Ultimately, yes. And I think that as we make that decision, I, for one, would appreciate input from folks who deal with these volumes and analyze these volumes, enforce these volumes on a regular basis, of which I do not. And if other commissioners want to jump in with their expertise, they're welcome to. But I think this is one of those points where we've got to rely on staff to at least tell us, hey, these are tiny amounts, these are huge amounts, these are threats, these are, nominal impact, right? And if there's a way to, I don't know. I'm reaching at straws here. So if I need to quit and just move on, I will.
Commissioner Gonzalez, I'm not going to answer your question, but I do think that this topic was debated heavily during the mission change rulemaking. I think we have lots of information that was provided through the 900 series rule deliberations. I appreciate your question, and I'm happy to deliberate with you about it through deliberations, but I do want to acknowledge that there was significant testimony provided and deliberations that occurred on this topic through the mission change rulemaking.
And I recall much of that, Commissioner Messner, so I will look forward to you helping to educate and fill in whatever I missed in deliberations in terms of 42 cubic feet and what that really means. Because that's something that's missing in terms of how I'm applying our rules and this application to, actuality, I guess. Back to you, Chair.
Commissioner McGowan, you had earlier raised your hand. Did you get your question asked?
Thank you, Mr. Chair. I'm wondering if staff knows if the operator has been submitting, I guess I'll use the word accurate, Form 7s, which is reporting all venting and flaring amounts, which they're supposed to be doing. And I guess based on the testimony, the venting amount should be 0 because they shut down all the C wells, they're shut in. You might not know, and if you don't know, it's okay.
Commissioner McGowan, I go back to the example I gave you on that API number, and that was production data as of February of 2022. So that would be current for that particular well. And I went back 4 years, 2014. I see no gas report at all.
Okay, so maybe I'm misunderstanding. I just want to clarify. You have to report how much you're producing, but then you also have to report how much you are venting or flaring.
Or using, correct.
And for some of these things, we're missing data on all of those fronts.
Correct.
Okay, thanks.
Further questions, Commissioner Messner?
Thank you, Mr. Chair. I just have a general question for Mr. Leonard. What techniques have you seen utilized in the past around beneficial use of produced natural gas in different operations around the state. I'm just kind of curious of the different options that are available in your experience.
Sure, Commissioner Messner, that's a great question. We have seen operators, for instance, set generators to power all of their pump jacks. I think they talked that, you know, some of their pumping units were on electric, others were natural gas. We've seen operators set the generators, run their whole field on that. I don't know that the volumes are sufficient here, but we've seen other operators set up small NGL plants and make liquid natural gas and then transport it. We do have currently the crypto mining going on. So that's just a few of the things that we've seen that come to the, you know, top of my mind here.
And have you seen operators utilize the injection of natural gas?
Yes, yes.
And is there a minimum MCF or amount that has to be associated with those types of operations?
I can't answer that question. I'm not a geologist. A lot of it's based on the reservoir and geology, and you'd have to ask an engineer about that.
Sure. I was just wondering if you had any experience around that. So thanks for answering my questions.
Sure.
Further questions? Okay, seeing no further questions, thank you, Mr. Leonard, Ms. Byrne, Ms. Rosenberg, for the presentation. We will let you zoom away. Would identify Mr. Campbell if he had anything further from the applicant, given the testimony and questions from commissioners with staff.
Yes, Mr. Chair, I do. Thank you. I guess I have a question for Ms. Byrne. So on the Form 7 reporting, it's my understanding again that the reporting is incomplete, not inaccurate, right?
It's definitely incomplete. It's hard to judge whether or not it's inaccurate.
Right, but that isn't reason in and of itself to believe that Mr. Hearn has lied about the numbers that he's provided to the commission in his exhibits and testimony, right?
Again, it's incomplete data. I don't know.
Do you have any reason to believe that the data that Mr. Hearn has submitted here today for purposes of his testimony in calculating GOR is false?
The data that we saw is all data that apparently was collected at the previous compliance timeframe rather than any current information. So again, because of its incompleteness, can't make any judgments whatsoever about GOR, about the volumes that are being combusted or produced.
Well, so do you think staff signed off on a compliance agreement in January of 2017 that was inaccurate?
There was data provided up until the 2017 compliance agreement.
Based on your experience, is there reason to believe that the GOR over the last 5 years would demonstrably change?
Not as familiar with that basin as I am with others, but our GOR in other aspects or in other parts of the state actually goes up as wells decline. So I, again, have no frame of reference without data.
So you don't know, in fact, whether or not Mr. Williford's testimony earlier that as he's seen oil production go down, he's also seen the gas production go down is inaccurate. You don't have any experience in that area, do you?
I do not, but I also didn't hear any offering of metered volumes. If it was just a gut feeling.
But isn't it true that Rule 903D4 allows operators to measure gas vented, flared, or used by either direct measurement or by estimating gas volumes, right?
It does.
So he wouldn't need a direct meter then, would he? Not necessarily.
430 also says that it is directly metered unless a different approach has been approved by the director for all gas removed from the lease.
Did I misread 903D4 that says he can estimate gas volumes when he's reporting venting, flared, or combusted gas?
You did not misread it.
Thank
We
you.
don't have any reported estimated volumes.
Which isn't the same thing as saying that the volumes that we're relying on are wrong. You just don't have them, right? In the Form 7.
Yes, they also weren't in them. They appeared not to be updated from the previous compliance agreement in the variance request.
Mr. Chair, when you look at staff's PowerPoint, I'm sorry, at least my printed out version doesn't have page numbers, but it's the last page where staff has identified its quote unquote input. And there are a number of issues here that I'm not sure have been addressed. I don't know if they need to be addressed, but I want to be certain that the commissioners don't see any one of those reasons as a reason to potentially deny my client's variance request, at least without them following up with staff as to what do they mean by any of this and why is it relevant to the issues here today. And we continue to struggle with the notion that staff keeps saying, well, we don't think that we're going to take a position on the variance, but they have the burden of proof and they haven't proved their variance, which kind of takes us back full circle to where we were earlier today. We would have really liked the opportunity to vet these issues with staff. And although, Ms. Rosenberg is right, staff's not obligated to undertake to identify where there are deficiencies in the application. It did. And Rule 509 says that if staff is going to prepare an analysis, it's supposed to be provided to us. So I'm not sure where we go next, but I guess my ask to the commissioners is, do we have other issues here in these remaining bullet points on the last slide of staff's PowerPoint presentation? Excuse me.
If I may jump in, I just want to reiterate, staff is not secretly or trying to, in an underhanded manner, take a position on the ultimate outcome of this matter. Staff was simply identifying issues for the commission's edification and does not take an opinion or a position regarding what the outcome of staff's concerns result in. And I just want to be very clear about that. Thanks. Moreover, this is a brand new process, and so staff apologizes for any hiccups that it may cause. This is a new process with the variance. It's a unique issue. And so staff is learning along just like everyone else is in this regard.
Thank you, Ms. Rosenberg. Commissioner McGowan.
Thank you, Mr. Chair. I don't necessarily have questions about the last slide. I do have a different question for Mr. Wilford or his attorneys, which is, I think I read in the compliance agreement, which was attached to some of your submittal documents, that as part of the compliance agreement, the estimates for emissions and flaring and venting were all supposed to be updated. Did I read that? Did I read that correctly?
Mr. Williford's looking at it, if you'll give him a moment to review it.
Take your time, Mr. Wilford.
have to go back. I have to go back from, I think you're referring to item 10B in the compliance agreement. It says an estimate of the quantity of gas vented from category A and B wells during the reporting period. Is that what you're referring to?
I think so. And is the reporting period not the entirety of your compliance?
No, ma'am, that was the reporting period. We'll have to go back to the definitions somewhere.
Okay.
I'll try to find that quickly.
And then I'm wondering if Mr. Wilford wants to address why there is missing data that is supposed to be reported to the commission, and then how we know what numbers to be working off of.
Can't find the reporting period. Okay, reporting period. The reporting period was a period of time when Williford was no longer venting from category A and B wells. That was the reporting period. That's the definition of the reporting period.
I'm sorry, you came in and out for me. Could you repeat that, please?
I apologize. The reporting period is when Williford is no longer venting from category A and B wells. And venting is, we were venting at the well, not in our.
I see what, I think I see what you're saying, which is you're no longer venting, and so you're no
Not on the
longer.
A and B wells. No, ma'am, we are not.
And so to the second part of my question, can you explain why some of the data is missing in the reporting system for some of your wells?
I'm gonna have to say I failed to report it. I just didn't know. We reported it when we sold gas. When we sold gas, we reported it. That's why those numbers are good numbers. We have never provided, that I know of, estimated gas volumes from each well, other than when we worked on the compliance agreement. So
Okay,
I
thank you.
failed to do that. Yes, ma'am. It wasn't intentional. It's just, I have to claim I made a mistake. I apologize.
Okay. And do you have any idea why? I feel like we have dueling numbers, and even in some of the documents that were submitted into the docket, different numbers from you all. And in one instance, I saw 60 CFD per day, and now we're talking about 42. So could you explain that discrepancy?
I don't remember the 60. The only time I saw 60 would be on category C wells. We said wells, the Die Hard 8 and Schmidt 2.2 wells producing majority of the category's production at about 60.7 stock tank barrels per day. It was nothing about MCF.
Hearn, for the record, can you tell them what you're looking at? What exhibit, what page? Where are you looking?
I'm looking at exhibit 1. And it's the category C wells.
And so is that production, not venting amounts?
That is produced oil.
Okay.
It has nothing to do with the associated casing head gas.
Okay, thank you.
Commissioner Messner?
Thanks, Mr. Chair. Just a point of order. I mean, I think Mr. Campbell is expressing that he has some concerns around due process. And
I was about to go there. So
you want to just go there?
yeah.
All right.
So Mr. Campbell, if I could get you to visualize yourself and unmute. Great, thank you. So we've heard from staff. You've heard the information, the testimony from staff. Can you not hear me? Commissioners, can you hear me?
I can hear you now.
Okay. All right. So what I was saying is that we've heard from staff. You've heard from staff. We've got their written filings. Whether they're taking a position or not, you've heard as much as we have. At this point, do you feel it necessary to do additional rebuttal? Do you feel that in order to be satisfied under our 500 series rules, that a continuance would give you more time to be able to address the issues staff has raised? Where do you, or are you fine? Do you want to close your case and provide a closing argument? I'm really struggling to try to ensure that you and your client are given the appropriate amount of due process in a process that, as Ms. Rosenberg has mentioned, this is new for all of us.
So Mr. Chair, thank you. And we very much appreciate your sensitivity to that issue. May I ask for 5 minutes with my client?
Absolutely. Let's take, is 5 minutes enough?
Should we make it 10 just so people can?
Yeah, let's
take a
make it
break?
10 just so people can have a for real break. It's 11:48. Let's return at 11:58 and we will hear from you.
Thank you, sir.
Thank you. Okay, we are back live, Colorado Oil and Gas Commission, and we gave the applicant an opportunity to consult with his client. Mr. Campbell, do you have a report for us in terms of next steps?
I do, Mr. Chair. Sorry I interrupted you. We're ready to move this on to deliberations with the caveat that Mr. Williford just wants to briefly clarify 2 points. And the first is, you've heard detailed testimony today on how he estimated his gas volumes that are being vented and combusted. And with that said, Mr. Williford, what do you want to tell staff and the commissioners about Form 7 reporting?
First of all, I want to say, apologize it wasn't submitted properly. It's my fault, my mistake. The numbers that I have generated for this hearing today, I can do the same thing and correct. I'll be happy to go back and correct the Form 7s. We reported gas sold on the Form 7s. When we started venting, we no longer recorded that, or we should have, and that's my mistake. I would be happy to go back, and if the staff would like me to, correct those forms up to date.
And Mr. Williford, on the last page of staff's PowerPoint presentation, there's a bullet point where staff says it cannot determine how much gas is not going through the combustors. Can you address that concern of staff?
Yes, sir. The gas that's not going through the east and west combustors is the category C well gas. It is the 4 domestic taps that exist out there. I have 26 wells with gas engines on there. That gas that's utilized by those wells is not going through the combustors. And I believe that's all the gas that's not going. Oh, I have one separator, excuse me. I have one gas separator. That gas, the gas using to run that would not be going through the combustor.
Anything further, Mr. Campbell?
No, Mr. Chair, thank you.
Any questions from commissioners for Mr. Campbell or Mr. Williford following this final evidence? Commissioner McGowan?
Thank you, Mr. Chair. And not a question, but I just, for my own edification, the 60 MCF is from the gas capture plan that was submitted as part of your documentation. That is what is being estimated. for the category A and B wells, I believe.
Mr. Williford's looking at that.
No. I don't have those there.
And what page again, Commissioner McGowan, if I might ask?
Commissioner McGowan, you're on mute.
Sorry, I'm being asked to multitask. It's in your application, and I think it's on page 43.
That would be the attachment.
It's your Form 4 attachment.
He's found it. He's looking at it.
That was at the time, that was my highest estimate of what the gas would have been until I did the other calculations. It's very close. 60, I actually refined it to 55 was the up number. So I when I filed this capture plan, I wanted to be I just wanted to make sure I was covering my bases.
Okay.
I've refined that since in today's exhibits. And I also, at this time, even though I had plugged 2 wells, I was still using the data for those 2 wells. So I may have been just slightly high. I'm just sorry I didn't put 55 down as my highest number, but I put 60 in the gas capture. Very close numbers.
Okay, thank you for that. Commissioners, any further questions? Commissioner Messner?
Thank you, Mr. Chair. I just want to confirm with Mr. Campbell that, after having the time to interact with his client, that he feels like any concerns around due process has been met and there won't be any further arguments along those lines.
I think we've told you we're prepared to move this to deliberations.
Okay.
All right. Mr. Campbell, do you desire to present any form of a closing?
Rob, do you want to? Commissioners, I don't think we need to. I think you understand the issues and all the evidence is out there, and we've spent a lot of time here already today. I guess I would just finish with thank you for the opportunity to appear before you today. And Williford Resources is hopeful that it will be given this opportunity to try and find a way through this morass that works for it and the citizens of Colorado, and we hope you're willing to provide that opportunity. So thank you.
Okay, thank you. I don't know that we need additional closing from Ms. Rosenberg. We've heard from her. So I think at this point, Ms. Rosenberg, did you?
Really, we just wanted to say thank you and we're working through this new process, and we are taking notes for how to potentially improve the process as we go along. And just staff wanted the opportunity to inform the commission of what it perceived to be as gaps in data. But again, the staff does not take a position on the outcome of this variance request. Thank you.
Okay. Then, commissioners, I believe we turn it back to ourselves for deliberation on the request. Again, I would note that the request is to for a variance to allow the permit Williford to continue to vent casing head gas from category C wells and combust casing head gas from category A wells and category B wells, all for 1 year. I can start on deliberations with some thoughts about some of the legal arguments, perhaps, and then we can see if we've got consensus on that. Number one, there was a suggestion or an argument that Rule 903 is illegal or ultra virus or invalid on its face. I do not agree with that position. I believe that we accurately in the SBP established the basis for Rule 903, and the basis was based upon safety concerns, odor concerns, public health concerns, as well as the waste issue. I believe that, at least from this commissioner's perspective, that the concern about what is excessive or unreasonable flaring, I believe that we made that finding in the SBP and in our Rule 903. And I believe that from this commissioner's perspective, excessive or unreasonable flaring is any flaring outside of what is permissible under Rule 903. Secondly, and just to sort of address these issues sequentially, with regard to the argument that there is this agreement or a contract that can somehow or another halt our ability to allow 903 to be utilized, I disagree with that. I believe that the 2017 contract that was entered into is a contract. Their paragraph 13 allows for the commission to require the ceasing of venting at any time with 30 days notice. That's a termination clause, and the director has appropriately complied with it. So those are my thoughts on two of the sort of large scale legal issues that are presented to us. Perhaps we can hear from others on legal issues, and then we can turn to deliberation on variance. Commissioner McGowan.
I agree with you on both points, Mr. Chair, and I feel pretty solid about 903. It's been reviewed by multiple parties, our own legal team, the AG's office, and legislative legal services. And I think hopefully something, if they thought it was unconstitutional or unstatutory, would have caught it in those pretty rigorous reviews. I also don't think that it's appropriate for us in a deliberation to decide whether or not it is or isn't constitutional or statutory. It's gone through an appropriate review, and I don't think this is the appropriate venue for us to make that decision anyway. So I agree with you on both fronts.
Other commissioners? Commissioner Gonzalez.
Yeah, thanks, Chair. Yeah, I agree with you. I don't think that anything in the statute precluded us from promulgating Rule 903. I think 903 is a good rule. We deliberated on it. We took into account a lot of information as we did. It's been reviewed post, and we haven't had any complaints, filings, or challenges on that matter since. I agree with you on the legal perspectives.
Commissioner Messner.
Thank you, Mr. Chair. I mean, I concur. I think it's also important that the statement of basis and purpose gets read holistically and not cherry picked as far as certain sections and developing arguments around these things. And so, but I concur with all the points that were brought up by the other commissioners.
Okay, so it seems that we've got consensus on some of the large scale legal arguments. I believe now it's appropriate to weigh in on the variance request from Rule 903 at this time. Anybody want to lead off on thoughts there? Commissioner McGowan, then Commissioner Gonzalez.
Thank you, Mr. Chair. And I spent some time going through the statement of basis of purpose for the 900 series and 903 in particular, obviously. And I do think that 903 is clear that there's an opportunity for operators to ask for a variance. And in particular, there was an acknowledgement that circumstances could arise where an operator is in a situation where they are having to look at venting or flaring for in my mind, a finite period of time because of something that they did not anticipate. And I think that we have that situation here. I will say, I feel like a lot of different numbers have been submitted by the applicant, and it's hard to figure out which numbers I should work off of. For me, I'm going to work off of the 60 for the category A and B wells. I'm working off of the 60 CFD, sorry. And it to Commissioner Gonzalez's point of trying to figure out what is de minimis or is this a lot? Is it a little? How concerned should we be? So if I take 60 times 360 every day, I get 21,600 of something annually. And if someone is gifting me 21,600,000 marbles, that would be preferable to me from an impact perspective versus someone gifting to me 21,600 elephants, for example. And so I think it's important for us to try to figure out what the magnitude of this looks like. That being said, I don't think that the commission thought that we would be offering variances in perpetuity to continually allow venting and flaring. The goal is to wean ourselves off of this and minimize the public health impact, the environmental impact of venting and flaring that's coming from multiple sources. And sometimes they might seem small and de minimis, but when you start adding things together and looking at the total number of days that this occurs, it's a lot. So I am thinking that I'm open to looking at a variance for a year to allow the operator to look for more opportunity to figure out a beneficial use or appropriate source for the natural gas. I'm really struggling with the category C wells because I think those are based on the testimony of the operator himself. There really is no other option than continual venting. And I don't think that our rules and or the deliberation and why we put the rules in place are supportive of venting in perpetuity. And so I'm really struggling with that piece and what to do with it. I also think that if we contemplate a variance, we need to somehow have reflected in the variance that the operator needs to be in compliance with all reporting requirements, because I think it even gave staff a hard time to try to figure out what to base an opinion about when Commissioner Gonzalez was asking, like, is this a lot? Is it a little? I think that made the conversation difficult as well.
Commissioner Gonzalez.
Yeah, thanks, Chair. And I'm going to try not to bounce around, but I got a couple notes I'll walk through and just some things that I've been thinking about along the way. The first of which is that, when we put Rule 903 in place, we heard a lot of testimony that there is going to be some challenging operations across this state where connection to infrastructure is going to be difficult, if not impossible. We heard that through multiple parties testifying on that. Williford was not one, but we heard from others. And then in our statement of basis and purpose, we say, okay, we're going to give this year to allow for that infrastructure build out. Now, I don't know that infrastructure build out in a lot of cases can be effectuated in a year period. And I think that I voiced that back in mission change. I think we discussed that as well in our deliberations in that regard. And so that being said, I just want to acknowledge that this is something that we thought about and that we should have anticipated receiving these variances similar to the ones that we did for Jackson County and the North Park Basin. So that being said, I think that when I think about whether or not there was a good faith effort to comply with the rules, I also want to reconcile that year runway that we gave and think about that and think, hey, operators were put on notice. And I think this operator was in a little bit different of a circumstance in terms of this compliance agreement they had, in that they were relying on it, and that their termination clause was not tied to any rule or deadline set in our rules. And in fact, it was tied to an indefinite term with an off-ramp for the director and agency to give 30 days notice, of which they did, and of which that's brought Williford Resources to us today. I think that 30 days, if they were relying on that compliance agreement, is not enough to go forward and to evaluate, plan, and install infrastructure takeaway or any kind of mitigation on these flaring and venting volumes that are going from their wells. So when I think about that in terms of good faith effort to comply or unable to comply, I do think that's where that applies in my mind. When we think about venting, you know, I do think that the statute and the act itself, you know, do contemplate that for oil wells, that venting is almost a part of it, a necessary evil. And I think that with that expressly outlined in the definition of waste, and I'm just kind of making a loose analogy here, because I do not think that the arguments that because of that definition, it precluded us from putting 903 in place. I do think that is an acknowledgement at the very least of a reality that goes with oil production, specifically in areas where gas production infrastructure does not exist. And so that's impactful to me as I think about that. And I'm gonna apply that, you know, that as kind of where I'm thinking about, does this violate the basic intent of the act? And if the act contemplates that in general, then I have a hard time reconciling how it does violate the act. So that's an impactful point for me as well. Now, you know, as Chair Robbins mentioned, anything above our rules is excessive, right? Our rules call for 0 with some off ramps. And so in that case, you know, I think that's something that we have to consider in our deliberations, in our analysis. Now, when I think about these amounts, you know, whether or not we're talking about elephants or marbles, Commissioner McGowan, I'm going to go back to that. You know, I just think about it in terms of, I don't know what marbles are worth. I don't know what elephants are worth, you know, but I can think about it in terms of, you know, something that I know has very little monetary value, you know, dirt from a trail, somewhere in the mountains versus gold, right? You know, one has a quantifiable value and one doesn't. And I can tell you that 21 ounces of dirt and 21 ounces of gold are going to be worth different and have a different impact when I think about it that way. Now, this is just again, a loose analogy to kind of what I'm trying to reconcile in terms of the impact and the potential net adverse impacts of the proposed application and of the operations that are going on there. And we heard testimony that these are de minimis, that these are minuscule. And I really, really wanted to hear from staff in terms of, does staff agree? Do the engineers on staff agree that those are volumes that while they do exceed our rules, are they such that they would create the level of positive or negative net adverse impacts that would, you know, prevent us from granting a variance given the other circumstances that are before us today? And it didn't seem like the staff had quite a strong opinion or any opinion really on whether or not those were impactful or what that impact looked like. And so for in that regard, you know, I'm gonna rely on the applicant, because of the two parties that were before us, that's the only one that provided testimony and evidence in that regard. So as to no net adverse impacts, that's one of the arguments that I'm considering in terms of how I'm looking through this variance application. I think that it's important that we understand that this gathering system went down and no fault of the operator. Granted, it was a long time ago. The operator has put in other measures, namely putting their gathering system through combustors, which does reduce the hydrocarbon venting, which does reduce the VOCs, and I think that's an impactful and I guess effort by the applicant. Still results in venting, still results in release to atmosphere, which I acknowledge. I think that on the last part, when I think about COAs, if we do grant this variance, some COAs that I think I'd like to see are, I'd like to have a mid-year progress report that tells us, hey, where are you in terms of evaluating this reinjection, this beneficial use idea? And we heard that they're still kicking around other ideas, right? They're looking for any way out of having to vent their gas. And so I'd like to hear if other ideas pop up, what those are and how are they being thought about and what's next. And also I think a COA would definitely be, and I think Commissioner McGowan mentioned this, that we get those production reports updated ASAP. That's going to help get the staff and the operator aligned in terms of what volumes we're talking about. And I think that would be an important and impactful condition of approval of a variance should we choose to grant one. So it's kind of my thoughts, at least as I've run through the testimony, the applications, and what we've heard today.
Commissioner Messner.
Thank you, Mr. Chair. Thank you, Commissioner McGowan and Commissioner Gonzalez for sharing your thoughts. You know, this one I'm struggling with a little bit. I think that I think we have heard some variance requests associated with Rule 903. I think, as Commissioner Gonzalez indicated, there certainly were considerations given during deliberations and mission change rulemaking that there were going to be certain situations around the state that may need some additional considerations. And I think we built those considerations into Rule 903. I think that one of the important pieces of that is whether or not the applicant has made a good faith effort to comply. And to me, at least in the past, when we've seen variance requests, there's been significant documentation of analysis and understanding that, you know, this prohibition was part of the rules with limited exceptions, that there needed to be significant action taken in a limited time frame in order to be able to address the flaring and venting the natural gas associated with operations. There was documentation that was provided to show how they were going to comply over a certain amount of time. And I didn't see that level of information, analysis, or reporting associated with what the ultimate plan would be in order to be able to comply with the 903 rules. And so that is giving me a little bit of heartburn in this particular situation, because while we heard that there was some general exploration of different ideas, there wasn't any further analysis or a plan of action on how they were going to comply with the rules, even if there was a variance requested in this particular situation. Now, having said that, while I believe that every operator in the state of Colorado needs to pay attention and understand the rules in which they are operating under, and that's the responsibility of the operator to understand that in order to operate in the state of Colorado. It's possible that this particular operator did not understand that until they've got notice from staff that they needed to come into compliance or apply for a variance hearing, which I believe was in December. And so even though arguably there was 18 months since we initially approved the mission change rules, they went into effect. We approved them around Thanksgiving of 2020, went into effect in January of 2021. It's possible that this operator was not paying attention and did not know that there was action that needed to be taken outside of their 2017 compliance plan. And so I do believe that that's a possible undue hardship. I'm not sure that that still acknowledges the lack of a plan moving forward that shows a good faith effort to comply or steps to comply. But I do think that there is an undue hardship associated here. And then the question of whether the granting the variance will result in a no net adverse impact to public health, safety, welfare, the environment, and wildlife resources. I think that ties in again to the first necessary showing, which is the good faith effort to comply, because as I read holistically the statement of basis and purpose as it speaks to venting and flaring, it indicates that for a number of different reasons that there is a potential impact to public health, safety, welfare, the environment, and wildlife resources of venting and flaring without associated volume amounts, which is why we put in our rules that we are prohibiting venting and flaring in association with production of oil and gas activities in the state, with very limited exceptions. And those limited exceptions, in many cases have to do with safety. And so to me, the volume amounts, I believe that the volume amounts need to be accurate. And there's no question that there is some issues with potential incomplete information that was provided by the applicant in these situations. But the fact that there is anticipated venting and flaring that will occur at any amount, to me, says that there's a potential impact to public health, safety, welfare, the environment, and wildlife resources. And in order to get to the no net adverse impacts, I need to see a much clearer path towards compliance, so that I understand that if there was a variance granted, that there would be steps that could be taken in order to get this particular application, this particular operation into compliance with other beneficial utilization of this natural gas that otherwise would be vented or flared. And at this stage, I'm not seeing that. Now, I'm still balancing that with the undue hardship of the timing associated with it if the operator did not understand that the rules had changed 15 months ago. But at the same time, understanding that operators who are operating in the state of Colorado need to understand the rules in which they're operating under. So those are my initial thoughts.
I too am a little across the board on this. I think the thing that is most pressing to me is the testimony from the applicant that they had this compliance agreement and they testified that they were unaware of the new rule. And for that reason, I think I do find an undue hardship. I'm very concerned, though, that from all the testimony we received, that if we were to grant a variance, that we're not going to be in the exact same place 6 months from now, a year from now, because they did not seem to have any firm plan that is developable, other than the reinjection notion. Having said that, I would probably be okay in granting a time-limited variance with the conditions of approval as articulated by Commissioner Gonzalez and Commissioner McGowan as to the A and B wells only. And I would like to see a report back. I'm not even of the opinion that it needs to be a full year from today's date. They've been aware of the rule as of the day they received the notice from the director. And so perhaps it's a year from that date, because I do believe, potentially we're going to be back in the same place in a year, in a period of time, whatever that period of time may be. Commissioner Messner?
Thank you, Chairman Robin. So just so I understand your thoughts there. And I'm not looking at it right now, but I believe sometime in December of 2021 is when notice went out that they needed to be in compliance by January 15th of 2022. Are you suggesting that that date would start on January 15th, 2022, or the date of notice in December?
I was going off the date of notice because at that point, there's no, you don't get the benefit of not knowing the rules. I mean, I agree with you. I think this operator should have known the rules, just like I need to know whether the speed limit on my road is 35 or 45, and I've got to comply with it. But I would be willing to go to the date that the notice was effectuated and then run a year from that period of time for the B and C wells, or the A and B wells.
So from this commissioner's standpoint, because I acknowledge that there's a potential undue hardship here, I think that your suggestion of having it start at the date of notice in December for a 1-year time frame is a generous, workable solution. I think that the suggestion by Commissioner McGowan that there be a check-in at the 6-month point to better understand the progress that is being made on whatever options are being contemplated is also an important condition of approval on this. But I can support your suggestion, Chairman Robbins.
And that date for my fellow commissioners is December 16th, 2021. Commissioner Gonzalez?
Yeah, thanks, Chair. So I appreciate, kind of what you're thinking there. I don't know that we'll get a different result if we give them a year from today or if we give them 8 months from today. But essentially that's what we're talking about. If we talk about the December date, is eight months from this decision. So I don't see how a 6-month check-in would matter at all at that point. I'd be in favor of going for a full year from this date, and give the operator the full year to reflect on what we've asked, to implement the rules under 903, since the compliance agreement has since been terminated, or at least will be terminated most likely by this commission today. I'm not quite sure how that works with our variance process, but that's kind of one of the things that sounded like it was a part of this, is that needed to go to the commission for termination, or not quite sure if the director could do it. Nonetheless, I think 8 months is going to be aggressive. I don't know if I would expect to see much more than perhaps a more detailed plan and maybe some work towards that. I'd be more in favor of going to the full year from today's date. But if it's the pleasure of this commission and the majority of the commissioners to shorten that, I won't have too strong an objection to that.
Commissioner McGowan?
Thank you, Mr. Chair. I think I'm aligned with Commissioner Gonzalez. I think what rightly or wrongly, it appears to me the operator was not paying attention to what the updated rules were. And I think, unfortunately, didn't understand, even if you have a compliance agreement, all the rules still apply to how you are running your operations. So maybe there's a lesson learned here. I would prefer to give the operator the full year so that we don't hear in 8 months, I didn't get the full year, everybody else got a year to figure things out. I think that creates a level playing field from everybody else who were paying attention to the rule making. And I want to give the operator the full 12 months to figure out if there are other ways to deal with the flaring. Question to Commissioner Gonzalez. I think what I heard you say, when we're talking about in statute, whether or not venting or flaring is I think if I'm reading right, unnecessary or excessive left surface loss. And that's, I think, what you're tying into with the de minimis conversation. And then, sorry, multitasking is not working for me here. And if that is what you're saying, and we're saying that the Class C are de minimis emissions, what is your expectation for the Class C wells?
So, Chair. So, Commissioner McGowan, thank you for the question. That's not what I was tying to. I was not, and I know I rambled a little bit, so I apologize if it was tough to follow
You
me.
tied a lot of things that all pertain to what this rulemaking is about, and I'm just trying to figure
Sure.
out how the de minimis conversation fits into long-term potentially venting.
Okay, yeah, so I'll get to that in a second. When I was talking about the reference to the statute was simply about the violation of the act component of the variance elements. And so that's what I was relying on in that regard. As to the de minimis or minuscule volumes or any kind of volume determination, to me, that goes to the net adverse impacts that are potential that we're considering here. So that has nothing to do with the act or the statute or the language of the statute itself, so much as it has to do with quantifying the impact. You know, what is the impact of a post-combustion volume of, call it 60 cubic feet, you know, on a daily basis, or for the Class C wells, an amount that's not even enough to run an engine or to really even be measured. It has to be estimated based on the oil production. So it's kind of a number that's worked its way back in there. You know, does the presence exist? Is there venting? I think everyone says yes. But it doesn't sound to me like there's an amount where it's actually measurable. And I think that if something is not measurable, that it's pretty close to zero. And I think that's where I'm thinking that maybe this de minimis, this minuscule assertion by the applicant may carry some weight. And that's something that I was weighing in terms of my consideration of net adverse impacts. Does that answer your question, Commissioner McGowan?
Yes, thank you. Yes, and so looking at the five pieces of the variance request that you have to show that you jumped through the hoop opens the door to because when I'm looking at the Rule 903, the only condition, I guess, that this operator meets is F, which is for facilities that existed prior to the mission change. The intent is to get connected to a gathering line or capture rather than flare or vent or otherwise put to beneficial use. They don't really fit under the other for upset condition for all those other things. And so the variance would apply to F, correct, 903 DF. I may be making this more difficult than I need to be. I'm just trying to tie all the pieces together because we're talking about the rules requesting a variance, the rules that exist in 903D, and then I think trying to figure out is, as part of the variance, is there a net impact and net adverse impact? And I think what I'm struggling with there is, overall, if you are emitting and there's this baseline, is that an adverse impact? And if the operator says, well, it's so minuscule and I'm just continuing to do the same thing that I was doing before, there really was no attempt to reduce more. So are we looking at the baseline and saying the baseline had a minimal or no adverse impact in the first place? And what I'm asking making sense? I'm just trying to work my way through this.
Thank you, Mr. Chair. Commissioner McGowan, I think to your second point, I'm not totally following your question, but maybe I am. So, I mean, my thought process on this is there's not an associated volume in the 903 rules around what amount is more impactful. As you read through the SBP, even if you read holistically through the SBP, there's not a specific amount. It says that venting and flaring of any amount is impactful to public health, safety, welfare, the environment, and wildlife resources. There is adverse impacts associated with those. There are some limited exceptions within the 903 rules that we deliberated on extensively through the mission change rulemaking that indicate that there are certain situations that are going to cause some venting and flaring, and we will allow those in a very limited circumstance because of worker safety or upset conditions or a few specific reasons. And and again, it doesn't create an associated volume with those. It does create some timelines and or director approval on certain circumstances. But I think, to me, the way I interpret 903 and I interpret our deliberations and our statement of basis and purpose is that we made a finding that venting and flaring of any amount has a adverse impact to public health, safety, welfare, the environment, and wildlife resources. So as I look at this particular application for a variance, again, I tie beneficial use and no net adverse impacts together, because I think that there is an adverse impact. I think that we can minimize that. We can minimize and mitigate that net adverse impact if there is the ability for the operator to comply. If there's a good faith effort for the operator to comply, and they come up with a beneficial use of this natural gas, and if we create a limited time frame in this variance to allow the operator to come into compliance with the rules, then I think that has the ability to mitigate, to create no net adverse impacts in the long run, right? So that's how I'm looking at it. I'm going to go back to, I think, Chairman Robbins' suggestion. I have a hard time with making today's date as the first date for that. At a minimum, I think that the operator had to come into compliance on January 15th, 2022. And I think if we wanted to compromise that could be a start date and still create a timeline associated, because at least I think we heard in testimony today that there has been some interactions or consideration by the applicant around different ways to comply, different approaches to beneficial use of the natural gas. But to give a year from today with no clear understanding that there is going to be any progress or that there is any options is a little, I'm not sure that to me meets the no net adverse impact threshold.
I tend to agree with you, Commissioner Messner, in terms of they were on rock solid notice that they should have been in compliance by January 15th of 2022. And granting a year from that date as opposed to an earlier date of December, I think is fair. I also would note for everyone that's listening that if I grant this variance with my vote, it is very much based upon the compliance agreement that is a peculiar circumstance here. And it's not meant to establish that variances are going to be granted easily. I think our SBP specifically said that would be the rare exception, and I think this does fit that rare exception. I think still having some form of a check-in at some reasonable period does make some sense. I agree with the production reports need to be updated, but I think we heard the applicant indicate they're going to do that anyway. Those are my additional musings. Commissioner Gonzalez, you'd raise your hand.
No, I don't have anything to add. I was going to address some things that Commissioner Messner said, but he's got the law and the SBP down, right? I agree 100% with what he said. I think that when I think about net adverse impacts and I think about that we did put a 0 in there, right? No venting or flaring in our rules, and that necessarily contemplates that any venting and flaring would result in a net adverse impact. I think that we did that just, for one reason was the difficulty in quantifying where that trigger point may be from a certain volume and what that may look like from an adverse impact. So I'm not necessarily aligned with that any of any volume of any amount is going to result in a net adverse impact. I do agree that our rule does prohibits it, right? And what's being asked for today is a variance from that rule. But I think that when we think about actually looking at matters on their own merit, and again, I don't have the benefit of really understanding these values, same as I don't think we did emission change either. Is there at some point, when we get so close to 0 that it's effectively the dilution or the location or the amounts or the volumes or whatever essentially don't reach that same level of impact that was contemplated when we took the a somewhat protectionist view in terms of creating our Rule 903. So I was just gonna muse on that. Doesn't change my position. I'd be happy to put forward a motion on this if it's ripe for that.
Commissioner McGowan would like to muse a little more before we get a motion.
Yeah, thank you, Mr. Chair. And this is just a little small thing, but there seems to be some confusion about if you're not going to use metering, what estimation means, and estimation has to be approved by our staff, the methodology that you use. So I just want to be clear to the operator, don't just estimate on your own, get something approved by our staff.
Commissioner Messner.
Thank you, Mr. Chair. Just point of order before we get into motions, but should this commission lock on a vote, does the outcome of that mean that the variance is by law denied?
I have my opinion on that, but I'll let AG Davenport weigh in.
Thank you, Mr. Chair. Can you hear me, commissioners? I'm having some internet stuff, so I kept my video off for this.
Yep,
Okay, thanks.
we can hear you just fine.
Yes, is the short answer. Any motion requires a majority approval vote, so a 2-2 tie is a denial. And ultimately, if the commission cannot come to a motion that cannot comes to a majority vote that approves the variance in some form or another, then it is a denial as well.
Thank you.
Commissioner Gonzalez, you had indicated you would put forward a motion. Do you want to do so?
Yes, Chair, I will go ahead and put forward a motion. We may not be aligned on the time frame, so we'll leave that for discussion upon vote or what have you. But I'm going to motion that we approve the variance request by the applicant for 1 year with a COA for a check-in 6 months from this date, or whatever is the nearest hearing date to that. That production reporting be updated within 30 days. I think those are 2 COAs that I was contemplating, so put some framework on that, and I'll throw that out there to see if that works, but that'll be my motion.
And Commissioner Gonzalez, is your motion as to both sets of wells, the A, B, as well as the C?
Yes.
As requested by applicant?
Yes, I'd like to give the applicant an opportunity to see if they can come up with some idea on how they can take care of the C wells. It doesn't sound like it's very promising at this point. It sounds like that's the nature of how those wells produce. They're currently shut in. But if the operator has, an opportunity, or if there's something that comes out of other ideas that unlocks potential for that, I want to leave that open.
I'll second the motion.
I think for the motion to be, well, with regard to discussion on the motion, we do need to fill in the date. Today's date, January 15th, December 16th, 2021.
Today's dates, April 20th, 2022. 1 year being April 20th, 2023, 6 months being October 20th, 2022. 30 days being May 20th, 2022. I can clean that up.
Alan, do you second that clarified motion?
Yes, thank you, Mr. Chair.
Commissioner Messner?
Thank you, Mr. Chair. So I'm a no vote as the motion is proposed at this point. I do think that if there was more clarity around what their plan of action was as far as how they're going to come into compliance with the rules, if they had done additional work between December and today to have a better understanding or plan of action before coming before us for a variance hearing, I think perhaps I would understand utilizing today's date, the lack of information that was provided, the lack of detail that was provided in any kind of potential path forward, even if they had 4 or 5 months between notice and today, knowing that they were going to have a variance hearing to provide a plan is not, I guess, is not influential enough with me to utilize today's date for this particular hearing. I mean, we could have stuff scheduled 2 years or 2 months, 3 months from now, and have a similar situation. And, you know, I would have the same opinion. I mean, there's got to be a plan to show that there was a good faith effort to comply, to tie together with the no net adverse impact finding. And so, I mean, I could suggest a friendly amendment to shift it not to the December date, but to the January 15th date. But to utilize today's date, I feel is inappropriate.
I am in agreement with you, Commissioner Messner, for all the reasons you articulated. Commissioner McGowan?
Thank you, Mr. Chair. So I'm going to give a plug for a year. I want to give this operator every opportunity to come into compliance. I think that a lot of what I talked about during our mission rule change was helping operators succeed under our rules. And I think the year gives this operator then plenty of time to figure out how to comply and meet the expectations of the rules. I also, given the conversation and not knowing if we have marbles or elephants and how much this actually is, I'm not sure it's an excessive amount of emissions. If we were talking about a lot of emissions, I might want to tamp the timeline down because I was concerned about how much was being emitted. I think this operator has already made attempts to reduce emissions through the compliance agreement. I think there's some work that needs to be done and some assistance with this operator to understand what the new rules are and how to comply with them. But I want to be able to say at the end, we gave a long runway to figure this out and come to compliance with what we're trying to do through these rules. So I'm supportive of the year. And I also think we've given some other folks who have had much more major concerns than this operator some pretty long runways.
Commissioner Gonzalez?
Yeah, no, and I appreciate that, Commissioner McGowan. You know, one thing that was impactful to me and one thing that it seemed, and with no objection from staff, was that when the compliance plan was put into a place, that this operator had adhered to it, right? And did what was necessary. I anticipate they're going to take our feedback well and will engage and are going to try to figure this out. Now, I don't know if they will or they won't, but I do think that we are putting in something, we are giving direction today. Today gives them a year. Stand by my motion of a year. I think that's appropriate, and I piggyback on everything Commissioner McGowan said.
All right, we have a motion and we have a second. I'm not seeing further deliberation or further discussion. Do we want to take a roll call on the motion?
Can I have a clarification, Mr. Chair?
Yeah.
just because this motion fails doesn't mean that someone can't introduce a second motion with a different timeline or whatever, and then that's what we pass instead.
Commissioner Messner, would you explain your head waggling?
Well, I mean, ultimately, AAG Davenport needs to let us know here, but my understanding is if this motion is deadlocked, then this application would be denied.
I could introduce a second motion that has a different timeline in it.
You can introduce it now, but you can't
Okay.
introduce it before we vote.
Mr. Chair,
AG Davenport, please weigh in.
thank you. No, I'm sorry, Commissioner Messner, I did not mean to indicate that. I meant to say that more that the process that Commissioner McGowan was just asking about is the correct process. In other words, if this motion fails, another commissioner could introduce a different motion that could pass potentially. But ultimately, if there is no motion of any kind that the commission can reach a 3-1 or 4-0 vote in approval on, then the application is denied.
Commissioner Gonzalez.
Yeah, I'm just going to suggest that maybe we save ourselves some time. And while I do think that a year is appropriate from today's date, I would be willing to accept the friendly amendment offered by Commissioner Messner to have a start date and a 1 year from January 15th, 2022. So to avoid potentially this motion and a second motion, and I think I can read where everyone's landing. I will amend my motion to a date 1 year for Class A, B, and C wells, all the wells that are at issue by the applicant. The variance as applied for, expiring January 15th, 2023, with a check-in of, I would say maybe 4 months from now. We'll kind of split it, call it August of 2022. And that they get all of their production reporting in-house within the next 30 days.
We have a amended motion. Do we have an amended second?
Second, yes.
Okay, we have a new motion on the table. Is there further discussion? Seeing no further discussion, all those in favor of the motion indicate by saying aye. Aye.
Aye.
Any opposed? Motion carries. I believe that concludes business for today. Does any commissioner have anything? Seeing none, I think we're looking for a motion to adjourn.
So moved.
Second.
Motion and second to adjourn. All those in favor signify by saying aye.
Aye.
Great, we are adjourned. Thank you very much, commissioners, for your good work. Thank you to staff and to the applicant for their presentations. We will now be adjourned.